Well, the original side. I'm sorry, my lord. There's an appeal.
Why are you sorry?
Unusual prayer. Unusual prayer. The reason is an appeal from a decree, the testamentary proceeding, and the caveatrix. I lost. Now the name, my name is SOVA, Shobha. Now in the cost title throughout the proceedings before the first court is recorded as SOBHA, Shobha. Now my Aadhaar card and everything is SOVA. SOVA. Now this
Your real name is SOVA.
SOVA. It is in the records is SOBHA. Now the department is saying because of this difference that it is not being filed. Now with the leave of the court I can file it then. The appeal.
Appeal and stability.
Throughout the appeal and the stages. Throughout the proceeding it has gone as SOBHA.
Don't you need to keep
You can put it as an alias, alias.
too much But don't you need to get it corrected before the trial court also? The trial court records.
But trial court records were that is disposed of today before the
doesn't matter.
Before the first court.
Yes, 151, 152.
No, it's an appeal from this order passed by this court. Order passed not by the
Then just go and mention and say that
this is Rao manner. That's the only.
No, because next door.
in the cost title decree everywhere it is BH.
Yes, but then you have to get that corrected also.
All along.
Yes, otherwise this anomaly will remain for eternity.
Yes, and my Aadhaar card is SOVA.
Yes. Write it out there, mention tomorrow and see. See, and then if necessary, come back.
My lord, if I may be permitted to mention, Lordship, I'm seeking leave to file an appeal without certified copy.
Original side?
Original side.
When was the order passed?
It was passed on 20th June, my lord.
Applied for certified copy?
Certified.
Leave.
Grateful, my lord.
This is my appeal, Millet. Pursuant to my lord's order, Millet, I've filed a supplementary affidavit, Millet. I've served upon my learned friend on the other side.
Where is your learned friend? We directed you to file a supplementary affidavit.
Yes, by my lord's last order of Millet. 8 July 2025, Millet.
We directed you file an affidavit.
Yes.
We directed you to file an affidavit.
Yes, Millet.
Or you wanted to and we permitted you.
Yes, I'm sorry.
No, there's a lot of difference.
I sought for leave and Millet had allowed the leave.
So there's a lot of difference in that.
Yes, Millet.
Please choose your words properly.
I stand corrected.
Yes.
I stand
we
corrected.
don't direct such things.
Yes, Millet. I stand corrected.
If you want to, we permit you to file.
I sought leave to file the supplementary affidavit to bring on record certain post-appeal events, Millet.
Very well. You are for the appellant?
Yes, Millet. I'm for the appellant.
What to do? They are not here. We take this on record and adjourn it for a day or pass it over. Wait, এটা দাও রাখো. Pass it over. 6 বছরের দেখেছি রাখো এটা আজকে দিল ফেরত দিয়ে দাও ওকে ঠিক আছে কি হয়েছে তাতে কি হলো রিকলিং তো কি হলো কি কোথায় লেখা আছে কোন Is a recalling application
before a different bench
in a contempt application. So this bench contempt not today. Did you not approach the learned trial court for vacating the receiver's order?
No, my lord.
Why?
Because, my lord, the moment we got to know about the order,
Yes.
my lord, it was at the time when the possession was taken back forcefully from my side. The company, the finance company is situated in Pune. My client is in, my lord, Punjab. They took, my lord, they have filed Section 9 petition in City Civil Court.
How much is the due?
My lord, due amount, my lord, I have made a chart.
Have you served this?
Yes, my lord. May I file my affidavit of service? All the, my lord.
Hire purchase.
Yes, my lord.
Hire purchase.
Two copies like this.
Why should we interfere, Mr. Tiwari?
My lord, I shall address on this. My lord. May I hand over the copy of the affidavit of
आगे
service?
सर्विस टा देखो देखिए
मोबाइल में खोलो कोई बात नहीं आ रहे हैं पुलिस में 5 मिनट
yes
but may I place the interim order mill at once?
yes place it as you should understand we have read it already.
Yes, my lord. I am fully aware that my lord have read it, but
Yeah.
but still, my lord, what has happened, my lord, the moment the receiver along with the police help had come and took over the possession of the assets,
Yes.
but then
What is the asset?
but assets are 2 printing machines. My client has several, my lord, loan accounts, at least, my lord, 8 accounts with the respondents.
So 3 to 6 or 7 say I 3 to 8
Yes.
similar matters.
Yes, my lord. So loan amount was being paid, but there was only two
You're
default.
appearing in this matter?
Lord, I appear for the respondents, my lord. I have instructions to appear, my lord.
The finance company.
Yes, my lord. My lord, Mr. Shakku Sen is appearing in this matter.
Let us hear him first. Just take your seat. Take your seat. Yes, Mr. Tiwari.
My lord, I have been instructed that we had paid the amount in December and January. There was default with regard to the amount from January and February only. March, April, May, we have made substantial payment to them in, my lord, lump sum amounts.
So
But
why-
there was a default, and the default amount that my lord has inquired about.
Mr. Tiwari,
My lord.
go back. It's an ex parte order.
Yes, my lord.
Go back. Convince the learned trial judge that this order is
In
unwarranted.
possession, they are going to sell the asset.
We will ask them not to sell for the timing. Don't sell the assets immediately.
Sir, my lord, it's with the receiver, but those are my instructions.
At
Very
least a
well.
copy
We
of
will
the-
clarify that they will go back to the learned trial judge, do whatever they are advised to do, and the learned trial judge will finally decide the Section 9. Section 9 has not been finally decided.
No, my lord.
So you go there, approach. Esho. This appeal is directed against an order dated April 25, 2025, passed by the learned 13th bench, City Civil Court, Calcutta, on an application under Section 9 of the Arbitration and Conciliation Act, filed by the respondent herein. Stop. Paragraph. Respondent herein being Miss Case number 2952 of 2025. Paragraph. It appears that the appellant herein obtained financial accommodation in connection with a hire purchase agreement for purchase of certain equipment. Stop. Apparently, installments fell in arrear. Stop. Accordingly, the respondent finance company approached the learned trial court under Section 9 of the 1996 Act in view of there being an arbitration clause in the hire purchase agreement for resolution of disputes and differences between the parties. Stop. Paragraph. The learned trial judge, noting the submission made on behalf of the finance company that the appellant herein are trying to create third-party interest in respect of the subject equipment oblique machines, comma, appointed a learned advocate of the City Civil Court as receiver and passed the following direction. করে এই impugned order করে দিচ্ছি আমি ব্র্যাকেট করে দিচ্ছি paragraph. Being aggrieved, comma, the respondent in the Section 9 application is before us by way of this appeal. Paragraph. Mr. Tiwari, comma, learned advocate representing the appellant, says that the receiver, comma, with police force, comma, has taken actual physical possession of the concerned equipment, which has stopped the appellant's business altogether.
Not all the assets, some of the assets.
This is what they are saying.
Milord, I have additional statement to make, Milord. They have taken, Milord, machines that are not hypotheticated. I have a list of that.
Stop. He also says that the receiver has taken possession of other machines which were not financed by
Yes, Milord.
the respondent herein. Stop. The respondent company, respondent herein, actually respondent. Stop. The finance company is in the process of selling the equipment oblique machinery of which possession has been taken by the receiver. Stop. This will cause irreparable prejudice to the appellant. Stop. Though there was some default in payment of installment in the month of January and February, 2025, thereafter substantial sums have been paid by the appellant to the respondent. Paragraph. Although the respondent company is represented, we have not called upon learned senior counsel, Mr. Shakko Sen, representing the respondent company. Paragraph. We are of the view that the appellant should approach the learned single judge and ventilate his grievance. Stop. However, till the appellant gets such an opportunity, we direct the respondent not to sell off or create third-party interest in respect of the subject machinery oblique equipment. Stop. This interim protection granted to the appellant will continue for a period of 1 month from date and will be subject to any further order that may be passed by the learned trial court.
Only
Yes.
record one submission, my lord, that the receiver could not locate most of the machineries which he has been directed to take possession.
একটা যেখানে Mr. Tiwari or Mr. Sen, ওখানে called
He must at least comply with the
not
order.
called upon টা করো না বলো না তাহলে Mr. Shakko Sen, learned senior counsel representing the respondent finance company, says that the receiver could not locate many of the equipment oblique machinery which she was directed. She is the same receiver in all the
Yes,
matters.
yes, my
Same.
lord.
Very well. Then which she was directed to take possession of. And the appellant extended no cooperation in that regard. Paragraph. Submissions made on behalf of the respective parties are disputed by the respected opposite parties. করে তারপরে ওইটা করে দাও করে appeal application dispose of
Milord, only one indulgence. One indulgence, Milord, minor. let them supply a copy of the minutes of the
How-
meeting
I am.
by which the possession has been taken. They must be having it.
Ask the receiver. Receiver will.
If the actor add করে দাও, if the appellant asks for a copy of the minutes
Deeply
of
obliged.
the meeting at which the receiver took possession of the concerned machinery, copy of such minutes will be forthwith supplied to the
I'm
appellant.
deeply obliged.
328, same order.
I'm sorry, I made a mistake. There are receiver
তাহলে ওই
appointed
ওই
in all the
she,
matters,
her ওসব
but
করো না।
both are her.
ও both are
Yes.
আচ্ছা।
So there was the
But,
interest.
kindly say that they should comply with the order. Because your lordship is not interfering.
Will that make any
Kind of
difference?
then deal.
Will that make a difference? That order is there. We have not interfered.
Will. I'm deeply obliged, in all
Yeah,
the
that's
items.
right, Shata.
Item 328.
Yeah, 328.
Again,
But they should not deal with that asset. Just as I should not sell
no
it,
problem.
they should not.
There is
deal
an
with
order,
that
Millard. Already there is an
asset.
order, section 9.
You have already.
Mr.
this, so that
Singh
the
will not
receiver
gain
could not.
anything. I leave it to your lordship. I will not.
এই
give the way.
আরেকটা দিয়ে দাও,
Yes.
দেখি তোমার কোথায় কিরকম এত কি শিখেছো, কোথায় ঢোকাবে ওটা। Likewise, the appellant shall also not deal with or create third-party interest in respect of the machinery and equipment which have been financed by the respondent company till further orders of the learned trial court.
Millard, then I have one more indulgence.
Yes.
They should also, Millard, not deal with the extra items that they have taken. That is not possessed, Millard.
No, that-
That is not
I am
hypothetical.
disputing.
That is why, Millard. Millard, I am placing the chart, Millard.
Whatever they have taken, they are not going to sell off. We have said so.
Has already been.
Possession, whatever they have taken.
My lord. I'm deeply obliged. I'm deep.
Nine is the same also.
No. Item 9 is separate, man.
Oh, review. This
that-
bench can't
no.
take it up.
Can it be on 24th then?
24th, very well.
Affidavit
24th
has been
call.
exchanged.
I'm for the
Affidavit
state's
I'm for
respondents.
respondents number 1 and 2.
Very well.
In opposition and reply has been exchanged.
Very well. Come back on the 24th.
And we are not filing the reply today.
No, don't
For any
file it.
purpose. I'm for the state's respondents.
Very well.
Order record হচ্ছে এটা কি স্যার কোন অর্ডার রেকর্ড না
এই সন্দীপ, প্রত্যেকটাতেই হবে by consent of the parties প্রথমে, the appeal and the connected application. Second call করো। কেন? আচ্ছা বেশি নেই তো, কটা আছে? রাখো। না না, এই শোনো শোনো, কমার্শিয়াল এসে গেছে, দুপক্ষ এসে গেছেন। সেকেন্ড কল, হ্যাঁ। Yes, supplementary affidavit, you got a copy?
My lord, yesterday, my lord. I will take instruction from my client, my lord, yesterday afternoon.
Yes, if you wish to file a response to the supplementary,
lord.
file it. Give the supplementary now. Supplementary দেখো, supplementary affidavit। শোনো, তুমি একটা কি করে দেখিয়ে নেবে আমাকে, কারণ ছখানা এক জিনিস হবে। Supplementary affidavit filed on behalf of the appellant. এটা কি দেখছি আমি? You are still authority?
No, but I am Bamalori.
Oh, I see. File on behalf of the appellant be taken on record. Stop. A copy of the affidavit has been made available to learned advocate for the respondents.
Respondent number one.
Respondent number one, who seeks a little time to obtain instructions. Stop. The respondent number one will be paragraph correct. Will be at liberty to file its response to the supplementary affidavit within a week.
My lord, within 15 days.
Within?
15 days.
Why your client is not in Calcutta?
No, my lord. Now, at present, he is out of.
Within a fortnight. From date ta diye diyo. Paragraph lists the matter on the following working day.
Although it has passed orders for them to file their affidavit, but my supplementary affidavit only has facts, which has been not
Facts.
only facts with regards to post event, and these are on record.
All the more reason, exactly.
No, they have
My lord.
the
Yes,
fact
my lord.
being
Yes,
the fact being that they had filed an appeal which was
Very
dismissed.
come back after a fortnight.
No, but जबरदस्ती पीछे जा रहे हैं ना मेरा matter. Admitted facts, righteous facts. चलो एक और arbitration act क्या? अब देख रहे हैं. Two arbitration acts.
এটা কার? আমাদের মানে অর্ডারটা কার? কন্টেম্প্ট তো দেখছি। তাহলে এই বেঞ্চ নিতে পারে।
I am
Huge.
requested that the advocate in this matter, my lord, the petitioner, my lord, he is on his way. I have been requested to ask for a short passover, my lord.
Passover? Passover?
My lord, in 12, I am for the respondent. I am for the appellant. My lord, in this matter, my lord, Mr. Anirban Rai, my lord, was appearing as my senior, along with Mr. Shuman Sengupta. My lord, I am told, my lord, because there is a change of guard, our lordship knows, my lord, but I am told, my lord, he is getting specially assigned in the matter. Lord,
He's getting specially assigned.
to have
Specially
engage. I
engaged.
mean, my lord, I stand corrected, my lord, to engage in the matter.
A lawyer did a special assignment.
My lord, stand corrected.
Yes.
So, my lord,
So
my
you
lord,
want
the
how
other
much
issue-
time? So you want how
My lord,
much
keep it
time?
in the next week, my lord. The other issue is, my lord, I just wanted to point out, my lord, the paper book which has been filed by my learned friend, my lord, does not contain the statement of claim, counter statement, and my lord, the reply to the counter statement, my lord, which, my lord, according to us, my lord, is essential. My lord, we want to
Appeal
file a
against 34.
supplementary
Appeal against 34.
34. Yes, my lord. We want to
You
file a
file it.
supplementary, my lord. We have prepared something preempting, my lord, if lordship permits, we can file it.
File.
Very
Give
good.
them a copy.
Yes, yes, yes.
You want to file now?
Yes, yes, we have
File
a
it.
copy. Yes. দিয়ে দাও, জজ সাহেবদের মোটা কপিগুলো দাও।
What have you called it? Supplementary paper book?
Supplementary paper book।
Supplementary paper book filed on behalf of the state.
আরেকটা দাও ভাই কপি।
Capital S দেবে।
হ্যাঁ 2 কপি
comma, be kept with the records. Stop. Given you a copy, Mr. Sen? Stop. A copy of the supplementary paper book has been made available to learned advocate for the respondent in court today. Paragraph on the request made on behalf of the state, comma, let this matter stand adjourned and be listed again on
weekends, my lord.
সামনে বৃহস্পতিবার দিয়ে দাও।
24th, right? 24th.
Has anybody been appointed as the new GP? No.
Yes, my lord. Mr. Amitobroto Roy. I'm grateful to your lord. এই নামটা দিয়ে দিচ্ছি। এটা দেখে
Your Lordship, I'm appearing on behalf of the appellant, Your Lordship, in this matter.
Yes. 13.
13 and 14, Your Lordship. Both the matters, Your Lordship. Since it is appearing after a long time, we have no instruction received, Your Lordship, and there is a substitution application also pending, Your Lordship, before.
No instructions. So what do you want to do? Take instruction.
Yes, Your Lordship, I want to take this.
2014 appeal, madam.
Lordship,
15, sorry.
15 appeal, Your Lordship. One of the appellant have died, Your Lordship. Substitution application pending.
Does anything survive? What is this appeal against?
Your Lordship, I have to take instruction, Your Lordship.
Oh, you remember nothing. Take instruction, and more importantly,
Whether there is anything.
come and appear only you obtain material instruction. Otherwise, don't come. We'll dismiss it.
As Your Lordship.
How much time you need?
Your Lordship, kindly for 2 weeks, Your Lordship.
Learned advocate for the appellant. কত নম্বর ভাই এটা? 13. For the appellant says that this is an old matter and she needs to obtain instructions. Stop. Further, comma, one of the parties has passed away during the pendency of the appeal. Stop. Paragraph on the request made by learned advocate, comma, let this matter stand adjourned for 2 weeks and be listed again on date দিয়ে দাও।
Lordship, item 11. It was just entering, and it was item 12 called.
We'll call immediately.
Grateful, man. No, I load. Okay, at the time of.
Pass over.
There are 15, my lord. It's my appeal, my lord.
Who's appearing for Mr. Shatarup Banerjee?
Right, my lord.
Have you seen him in court today?
My lord. Now, this is that matter, my lord, that question of 12.5, my lord.
একটা আমার pass over, second call, we'll take it up.
Mine.
কি হলোটা কি? সবসময় কনফিউজ।
Passover matter, item number 10. This contempt application first time, Your Lordship.
First time.
First time. Your Lordship's order is at page 24. Page 24. Relevant portion also will get page 26. Having heard the learned counsel for the parties, Lordship got, my lord. Page 26.
এই ডিটারমিনেশন হবে তো এই বেঞ্চের আছে তো?
This is an order. Lordship, you got, my lord? Last page, 41. This is an order. In pursuance of order section of correction, the hearing of the parties is concluded. There is no sanction plan, admittedly no sanction plan, and
So she has not demolished. This is your grievance.
yes, still that is existing in that.
You have served? No.
No, first time.
Ultimately, issue. This contempt application has been taken out, alleging willful violation of a judgment and order dated November 30, 2023, whereby a coordinate bench disposed of MAT 1995 of 2023 and the connected application. Stop. One of the learned judges who was a member of that bench, having demitted office, this matter has been listed before this bench. Stop. Paragraph. The operative portion of the relevant order reads as follows. Page 26. Mark করে দিচ্ছি। Bracket করে দিয়েছি। Paragraph. Learned advocate for the petitioner draws our attention to a reasoned order passed by the alleged contemner herein on March 22, 2024, which reads as follows. Page 41. Eto 5 line set out করে দাও। Paragraph. Learned advocate says that in spite of the alleged contemner having found unauthorized construction, no step has been taken by her, by her to demolish the same. Stop. This is in violation of the order of this court. Paragraph. Let a copy of the contempt petition be served on the alleged contemnor. An affidavit of service be filed in court on the next date. When should it be listed? How long it will take to serve?
Within 2 weeks.
Please the matter 2 weeks. Date ta diye dao.
Grateful.
Okay, sure.
Lordship, item number 11, Mr. Pothik Bondhu Banerjee is appearing for the appellant for
Mr.
Pothik Bondhu Banerjee.
Yes.
Lord, on the last occasion, I prayed an adjournment on his health ground. He has not yet recovered, my lord. He has got legs ligament tear in his leg, so he has been asked for.
He's leading you in this matter.
He's leading.
What have you
I'm
done?
not in the matter. I'm
You're
his.
not in the matter. Good. How long you want?
My lord, Thursday week.
2 weeks.
My lord.
On the last occasion, i.e. July 8, 2025, this matter had been adjourned on the health ground of Learned Arguing Council. Mr. Das is appearing,
Mr.
Nobuda.
Das is leading.
Yes.
Mr. Das.
An Arguing Council, bolo na. On the health ground of Learned Junior Council for the appellant. Stop. Today we are told that Learned Junior Council has still not recovered. Stop. 2 weeks adjournment is sought for. Paragraph lists the matter. Once again on date ta diye dao.
Hello. 31st. Thursday week.
2008 appeal, sir.
The appeal was heard. Even the respondent has the substituted respondent give a application to the to their advocate to not to appear.
Anyway,
well.
all we are saying. Oh, that's right.
That's matter. KMDF.
But still we have to hear the appeal.
Yes, right.
Just finish it off on the next day. Request Mr. Das to be here. Let us. 2008.
Appeal, my lord, from arbitration award, my lord. The petitioner, the appellant has to start, my lord. They're not appearing today. The respondent, my lord.
Which one? Which one?
The Devojit Day, my lord, that they're challenging the arbitral award.
ওই তো এ করতে হবে তাহলে রেস্টোর করে দেবো এলে usual order নাকি তুই কি কোনোভাবে ইনভলভ রিলিজ করে দেবো এটা ঠিক আছে
Ghosh.
Yes.
Gopal Ghosh was appearing for the appellant. This is the 37.
Not today করে লাভ হবে না তো কিছু this bench is not inclined to take it up, so dismiss করো না
But since this bench is available, may I take the liberty of indicating that matter, my lord, where Mr. Shobhai Chaudhary concluded his submissions and Mr. Banerjee and Ms. Shah were making submissions on the original side, though, my lord.
One second. We are not inclined to take up this matter on the personal. Hey, not inclined to take up this matter on the personal ground of one of us, Shaiben Namda. Paragraph, let this matter stand released from our list and be placed before the Honorable Naki. That he cover, Naki just. Say not today.
Yes, well, that
not
I
today.
believe
Not today. Is the other thing what were you saying?
Lord, the matter where with regards to judgment upon admission application from which we had preferred appeal, Lord, if it was being heard before this bench, it was heard at length, my lord.
Wait till next week. Wait till next week.
I'll just indicate Mr. Chaudhary is traveling because of his son's convocation.
Jishnu Chaudhary.
No, my lord.
Shobhoshachi Chaudhary. We'll accommodate, don't worry, we'll accommodate.
Your lordship's alma mater from where he's getting.
Really?
Cambridge.
Law?
Yes. LLM.
LLM. Oh, very nice.
So great.
I think 16 minutes.
praying for not today because of Mr. Shatrughan Banerjee is not in Calcutta today.
My lord, actually they were supposed to rely on certain judgments. The citation has been forwarded.
Oh, this is that one.
12-5 matter, my lord.
Section 15, Schedule 7.
My lord.
7th schedule.
Even schedule
Appointment of arbitrator in violation of
section.
And a section 34 has been set aside, my lord.
There are certain judgments, Lordship.
Very
My lord, the judgments may be.
Lordship, can it be passed over for 5 minutes?
Why?
Mr. Shatrughan Banerjee is here.
Suddenly he appeared in Calcutta. Just now you
I
told
was
us.
informed wrongly that he is not in.
No,
but
then
he is here.
henceforth we won't be able to rely on what you say.
Lordship, I deeply apologize, Lordship. I was informed
You should
wrong.
not make a submission because we always rely on learned counsel.
I tender my deepest apology. I was informed wrongly, Lordship.
Not today, not today.
Pass over, Lordship. Kindly make it
Pass over. আর এক second call করো করো আরেকবার call করো
Passover matter, item number 16.
not today.
My lord.
We passed it over as you said. How many times will you pass it over?
I tender my deepest.
It's what to do, Mr. Mukherjee. Appellate side শেষ হয়ে গেল? Commercial যাও।
This matter was listed, my lord, for us to file our written notes of arguments, maybe. Oral arguments were concluded on the last petition.
You're for sale. Who?
Mr.
Not today. Not today. This bench. Don't you see this bench? Oh, sure. ওটা তো পাঠ হাট করিনি।
Just the notes or oral arguments have been concluded.
That's true. That's true. No.
Last, the oral arguments have been concluded.
We understand. Look at the constitution of the bench, sir. This bench heard it.
No.
Then, not today. Tomorrow file it.
Or maybe hand it over to my lord's officers.
No, because the bench is not there today. Who appeared for SMS?
Mr. Markanda had come from Delhi.
Oh, that matter. Very well. Send VAT credit. Not today, just not today.
Item 4. Appealing for the respondent, Lordship. This was that matter where impugned judgment did not have some pages. Miss Noel Day was.
Oh yes, where is she? Passover, we have to follow our formula, Mr. Shah. Passover.
Passover matter, item number 4.
কেন 5টা কি হলো? 5টা ডাকলেন না? 5টা?
5 আছে।
In his own world.
As usual, my lord, I'm again ignored, my lord.
Number 5.
Who dared ignore?
No, my lord.
They appear for the response.
My lord, this is my lord appeal from the suit, my lord, which was I'm for the defendant. The suit, my lord, which was.
Mr. Banerjee, yes, you'll have to start afresh.
In fact, my lord, originally, my lord,
This
bench had on 16th May, my lord, when the matter, my lord, was first moved.
Very good.
And my lord, so, my lord, that's what I was asking for my juniors. I think, my lord, we are first, my lord, will recall, my lord. This is, my lord, they, my lord, said there was a works contract. Out of that, my lord, one bill out of that contract was paid, which is admitted position. Though, my lord, they had not disclosed that, my lord, in the claims initially. There are 23 bills, my lord, which are undated.
Without reference number.
Without any reference number, nothing. The 23 bills are malad in respect of which malad they claim malad money. There were other 3 contracts under which malad they supplied labor. This is malad an individual malad person. He supplied labor which was paid. Now, the construction, according to us, malad of the factory was already done. So there was nothing further, and we had consent to operate dollars. So there was nothing further for which malad he had to carry out the work so as to get malad this claim which he makes malad of 7.78 crores. We had raised a point of limitation for dismissal of the suit. The limitation question, malad, the suit was not dismissed on that ground. It went up, malad, in a revision before the revisional court, and the revisional court said, no, I'm keeping everything open. All points with including limitation has to be decided by the first court.
Suit was filed before which court?
Malad, this is malad before the commercial court, malad, the Asansol. So that point, malad, was left open. Then malad, I think malad, Supreme Court went up Supreme Court, whatever, malad, that order survives. When it came back, malad, the trial judge proceeded on the basis first, malad, with great malad, respect, I say, malad, 2 errors malad, which are malad, evident malad, on the face. First is the question of limitation he did not decide. He said, I've already decided limitation. Therefore, I'm not deciding limitation anymore.
Although the revisional court had said
correct. And malad, secondly, he has to look at malad, it's the plaintiff's case. Plaintiff has to come and show that malad, how malad, those 23 bills, which are malad, unnumbered, and malad, without any reference number, though malad, all the other bills are with number, and malad, with reference number, and malad, with date. How those bills malad, are, first of all, malad, raised and received. Second of all, malad, within limitation. Thirdly, malad, work was done. Because in the cross-examination, a lot of questions, malad, which go directly to really malad, the root of the matter, where he says, no, because malad, we asked taxes, whether you're paid, whether malad, service tax, then malad, whether in the balance sheet there is disclosure with regard to this material which you have worked. So nothing malad, came out malad, with so far as that is concerned. So malad, a lack of malad, evidence, total lack of evidence so far as malad, the 23 bills are concerned, and which also relates to malad, question of limitation. These are malad, the 2 issues malad, which malad, we had raised. Malad, kindly look at malad, the plaint, which is malad, at page 126.
paper books have been filed.
Yes.
আরে ভাই এগুলো নিয়ে নাও, পেপার বুকস দাও।
Page number 1, volume 1. Page 1.
Yes.
Malad, Ashok Kumar Dotto, then malad, Sonic Thermal Private Limited, that's malad, us. Money suit for recovery of 8 crore 63. Then malad, is paragraph 2. Work order malad, is dated 6 July 2009. Page 2, paragraph 2. 6 July, and the plaintiff, after completion of works of the different companies, submitted bills bearing 1 to 24 in time to time, but without paying the said bills to the plaintiff company. The different company is trying to occupy wrongfully gain, and even the different companies avoiding to pay such bill amount to the plaintiff company with some false pretext, and be it mentioned here, completion of works by the plaintiff company suddenly served an order of cancellation of the related contract in order to avoid payment of due bills amount to the plaintiff. Then malad, kindly come to next. And the suit is filed malad, in 2015.
1 second.
I'm sorry, so sorry.
Hey.
Termination of 2015.
আমার নেই মনে কি নেই
ঠিক করা আছে হ্যাঁ হ্যাঁ সরি
amendment
Yes.
Well, paragraph page 2, paragraph 2 I read, then paragraph 3.
Yes.
That from the aforesaid, from the submitted bills bearing 1 to 24 by the plaintiff to the defendant company, appears that the plaintiff company is entitled to get rupees 8,63,64,78, and the aforesaid bill amount has been assessed properly, and also the defendant company has received the aforesaid bills from the plaintiff, and when the plaintiff requests the defendant to pay him the aforesaid amount of money, defendant company began to spend the days with some false pretext. So on that first claim, 8,76 in respect to all the 24 bills. Then at last on 20th March, when the plaintiff demanded the aforesaid bill amount from different company, with malafide intention replied in bogus manner by saying all payments has been made in the reply dated 9th April 2015. Statements account acknowledging receipt. Then 5, defendant company is also denying continuance of civil construction works by the plaintiff company. Kindly see, they will say that the defendant company is also denying the continuance of civil construction works by the plaintiff company after the period of December 2010. But from the relevant documents issued by the defendant company, it appears plaintiff company was engaged in the alleged work by the defendant company up to January 2015. This also they have to prove. Then finding no other alternative, plaintiff through his advocate sent a letter 2015, then tried to recover his best, then due an outstanding. This is what they say. Then paragraph 10 also can note that they, on the question of limitation, they said cancellation of contracts without paying all dues further on 9th April 2015. This is what they say on question of cancellation. But work done is contract 2009, and they said we are also saying contract work done by 2010. That is the case which they done. Then kindly come to the written statement which we filed.
Page 13 is our
page 13.
There was some amendment, was it?
Yes, there's an amendment, which I'll show with regard to when we pointed out, no, the first bill out of those 24 bills we have received and we have paid. That's when they gave credit for that first bill.
Page 13.
Page 13 is the original written statement. That's just junior. 12:15 में पढ़े तो मैं नहीं लेना भाई
He's assisting you.
Yes, my lord.
I don't have the gumption to assist him. I'm there.
Very rarely do I get his assistance. Literally, and otherwise also.
Moral support.
Page 14,
Yes.
That with reference to paragraph 2 of the plain, say what appears there from the record, defendant denies all allegations and such, category denied completely several work orders as per the request defendant, or through any work order dated 6 July, request denied completion of plaintiff. Also denied that after completion of the works, plaintiff had submitted bills bearing 1 to 24 from time to time, but without paying the said bills, defendant company is trying to occupy wrongful. Company is avoiding all such bills. Then in the middle, we'll find it is also categorically denied that after completion of works by the plaintiff company, defendant Sunday served an order of cancellation related contract in order to avoid payment of due bill amount plaintiff. Plaintiff was supplying laborers to the defendant company during construction period company till the defendant company started operation of the factory in the year 2011. And thereafter, the plaintiff had worked as labor contractor and supplied laborers to the defendant company once the company started working. There are 3 other contracts for that, my lord. I'll show those contracts. Bill numbers 1 to 24 as claimed by the plaintiff, excepting one bill out of them that are false, fabricated, and have been prepared for making unlawful enrichment. Only one bill was raised out of the said 24 bills as was received and paid by defendant. Remaining 23 bills as discovered by the defendants are false. That said 23 bills were not having an invoice number or dates. The defendant company has not received any such bill, and the seal of the company showing acceptance of said false and manufactured seal is a counterfeit of original seal of the defendant company. The plaintiff company filed a complaint, criminal complaint. Then, my lord, kindly look at paragraph 10, page 15 at the bottom.
Anything happened pursuant to that criminal complaint?
Yes, my lord. Sorry, my lord, I did not read that. Page 15. Filed at the top complaint to the criminal court 56(3). Non-payment company regard to bills being subject matter of the presence of police was directed to draw FIR by learned magistrate, police authority. Under course of investigation, professional chartered accountant was engaged to test the veracity of claim. A plaintiff was engaged to test the veracity claim of plaintiff. There was seizure of bills and other related documents plaintiff from the custody of defendant plaintiff. Report of chartered accountant after investigation filed to effect that the document support of claim do not support the claim of the plaintiff, does not support the claim of the complainant plaintiff. It is true that all the contract given to the plaintiff defendant was cancelled by letter dated 7 December 2015 and all dues of plaintiff was
The report of the chartered accountant is on record, which says that the documents don't support the plaintiff's claim.
But I think there's a final report. I'll just check. 1153.
Second final report is there.
Chartered accountant report ta kya ache na? Well, that is there. 1153. Sorry, volume 2 eta hobe. Page tai to 1153, volume 2.
Volume 4, part 2, volume
Oh, sorry, volume 4.
1153.
11.
Part 2, volume 4.
Sorry.
How many volumes are there?
5 volumes.
5 volumes are there. Sorry, my lord, mine's been made into, I forgot that other. Okay, volume 5.
Volume 4, part 2,
Volume 4, part 2, 1153. Chartered accountant report ta to nahi on record.
Criminal proceedings are all dropped.
Oh,
Again starts.
No. 1153.
Did you trial court paper attached?
Yes, my lord, quote of the FIR number, my lord, it's not an FIR. The chartered account is report, my lord, I do not.
Yeah, that's what report I was.
No, report is.
Share the.
Complaining could not show serial numbers.
My lord, only my lord, this
যেখানে ওই ডকুমেন্টস গুলো থাকে আমাদের দিকে তো
I don't mention করা আছে দেখে জানি না my lord only one thing I can show my lord in this at 1155 my lord this is what it says on going through the documents. This is my lord Arup Shorkar, inspector in charge. I'll just read that my lord if it's required my lord. I'll just on going through the documents and CDs and MOE it appears the claim raised by the complaint not at all sustainable on the following reasons. On and from 1st February, complainant was civil control liberator of the alleged company since was terminated. Contracts some specific allegations. Are that thereafter the complainant originated those bills for which he claimed a huge amount. Then, my lord, K says in spite of thorough search investigation by IU and even making a thorough investigation chartered accountant company, Goenka and companies and such, claims as per the 23 number of bills as raised in the FIR could not be sustained. That's my lord what it says. Anyway, my lord, we'll come to that, my lord, later, my lord, when the time comes. Now, my lord, coming back to my lord, the written statement at volume 1.
এটা হচ্ছে plaintiff defendant আলাদা
My lord, page 15 I read.
এর হচ্ছে বিলগুলো
Kindly look at my lord, paragraph 10, my lord, at page 15. That in respect of the statement made in paragraph 3 of the plaintiff, it is categorically denied by the defendant that the plaintiff is entitled to get 8 crore 63 or any amount more or less. It is also denied that the plaintiff has any amount due from the defendant to the tune or any tune on any account whatsoever, either on the basis of the alleged bills or any account. Also denied that the aforesaid bill amount was assessed properly or the defendant company had received the aforesaid bills as alleged. Neither these alleged bills as claim was even reached to defendant company nor any amount is due and payable to the plaintiff by defendant as alleged. Out of the 24 bills as claimed, 23 bills are false and only one bill was submitted against which payment as above was made in September 2011. If even after September 2011 till termination of cancellation of contract, number of payments were made to the plaintiff by the defendant against bill raised, but at no point of time till cancellation of labor supply contract, any claim was made against the alleged 23 bills. And the false claim is conspired to be made after cancellation of contract in 2015. Neither in general ledger nor the books of accounts of defendant company reflected any such entry as claimed by plaintiff, which was proved by chartered firm in course of investigation, police and FIR. Yes, answer. Police case was ended in final report. The plaintiff company is now, but upon to explore the civil jurisdiction, realize the false claim plaintiff from defendant by abusing process of law. No amount was due to pay to the plaintiff, not obliged to make any payment as claimed. So this is what we say. Then they amend. So that resulted in a FRT.
Your complaint.
No, their complaint. Their complaint. Sorry, their complaint. They said, we had not made payment of the. It was their complaint. Their complaint where chartered accountant was appointed to find out whether the.
Appointed by whom?
The police investigating officer.
Money claim going to the police. Anyway.
24 hours am I detained?
It went against him. It went against him. That was the intention to put pressure in criminal law to ensure that the payment is made. So it went against him because chartered accountant found and when I come back to 1155, chartered accountant found that the complainant's claim could not be sustained. Now, kindly see the amended plaint, which is at page 7.
Plaintiff document. আমাদের
কি চাইছো?
আমাদের
হ্যাঁ 500 করতে পারো ডিভিশন চাইছো well it kindly comes through now the amended plaint কি খুলে sorry I'll just
আমি এক্সিবিট ডিটা খুঁজে
ডিটা কি
এক্সিকিউটিভ
পড়ে এক্সিবিট ডি পড়ে দেখো
আমি অরিজিনাল থেকে দেখিয়ে দিচ্ছি আপনি দেখেন
আগে এটা দেখেন sorry I
বের করে রাখছি
ঠিক but page 7 is the amended plaint and then kindly come to page 9 we'll find paragraph 5 6 and then kindly similar paragraph 7 that the plaintiff company tried his best to recover the bill amount from the defendant company, but the defendant company is too adamant to pay the aforesaid bill amount to the plaintiff company with some malafide intention in order to occupy wrongful gain, and defendant company is denying the liability in respect of paying said amount of money mentioned bill numbers 1 to 24 within the said RA bills. The defendant has paid rupees 98,14,918 to the plaintiff. This was not there in the original. That there is thus due owing to defendant company, plaintiff company sum of rupees 8,77 similar or different liable for due repayment and want to allow chances. So he says, but the total claim continues at 8,77. And that's what they claim in paragraph 11 saying it's 8,77.
Previously it was 8.63.
And just for the records in that sense the amended written statement is from pages 21 to 28 where paragraph 11 can just have a look. Lord, paragraph 11 at page 25. Sorry, Malad, just before that, since Malad had asked us, I'm so sorry, Malad. I think it's proper for me to also show that. Malad, page 25 at the top, Malad will find it's part of paragraph 10. Malad, the fifth line, neither in general ledger nor the books of accounts of the defendant company. Malad has that, Malad. At the top, Malad, this is 1, 2, 3, 4, fifth line, neither in general ledger. Neither account the defendant company reflected any such entry as claimed by the plaintiff, which was proved by the chartered firm in course of investigation by police on FIR, a connection with Barjora PS case number 100 of 2015. Police case since ended in final report. Plaintiff company is now but upon to exploit the civil jurisdiction to realize the false claim of the plaintiff from defendant abusing process. I say that since no amount was due to paid, defendant not obliged to make payment, category denied, entitled to any amount at all from the defendant, also falsely alleged when defendant requested sunset. Then paragraph 11. Reference to paragraph 4 of the plaint, save water matters record, deny all allegations made in paragraph under reference. Reiterated, it is repeated by defendant as was stated in letter dated 9th April of the defendant company. Claim of rupees 8 crores 68 against 24 bills are false to the court as no amount due to the plaintiff by the defendant. It is to state the civil works were completed in the site of the company by September 2011, and company had commenced its operation of factory from 2011, and as such there was no civil construction work done at the site after 2010. From 2011 till cancellation of engagement in 2015, plaintiff was working as a labor supplier, not for the plaintiff raised bills and payment thereof was duly made. In this connection, I created to refer to the proceeding before the learned Chief Judicial Magistrate, Bakura. 100 evidence include report of chartered firm with regard to self-same claim as was made in the suit at time of hearing, category denied. Company has replied in bogus manner by the plaintiff letter dated sunset. Then, Malad, can you just look at one more? Paragraph 12, Malad, last 4 lines we say, fabricating the last 4 lines, defendant submits plaintiff for fabricating false claim and manufacturing false documents and by preparing a forged seal with bills as mentioned, total 23 out of 24, not at all deposit plaintiff, nor any such. Malad, just kindly, Malad, make a note, Malad, I showed, Malad, that factory had commenced its operation from 2011. Malad, we have a factory license and a consent to operate, which were not actually, Malad, before the first court. The question was asked, we said we'll produce it. It couldn't be produced. That Malad official document. That Malad is also Malad the subject matter of Order 41, Rule 27, Malad here. Then Malad will kindly come to.
But although the company's seal was forged, you did not take any criminal action.
We Malad did not take any criminal action. In fact, they Malad took that criminal action Malad against us Malad so far as. And they submitted, or rather, Malad, they made the claim on the basis of the 23 bills in the suit.
Chartered account. Police found that there was something wrong. Police found that there was something wrong. Now, how much should I give? যেটা query ছিল, police had done it. Police had sorted out. It gave me a
Malad, the FRTT Malad will be relevant. I can show that Malad. Malad, I'll show the FRTT. It's relevant Malad because the police had taken an opinion Malad from the chartered accountant, and this is Malad what was Malad
subject to correction was not a part of exhibit.
It was. Exhibit.
Trial court records
Exhibit D.
It's recorded in the order also.
With objection though, but exhibit.
Trial court records থেকে তো এসছে
Marked as exhibit.
Marked as an exhibit D, collective. না ওটা আমি দেখে বলছি তা।
It's recorded in the judgment.
আরে এই তো দেখ।
It's part of trial court records. Malad, page Malad, 28, paragraph 18.
মার্ক করে রেখে দিই যখন
That the actual state of affairs is that the plaintiff was appointed as civil contractor for the company since 2009, and all his works as civil contractor was completed by the end of the year 2010. Company started functioning since 2011. Accordingly, all his dues as civil contractor and incident labor supply for the construction at site were over by 2011. All his dues were cleared and there are no dues on this account. Page 29, my lord. Defendant alternate states that any further claim is barred by limitation. After the company started working in the year 2011, on his request, plaintiff was engaged as a labor contractor and he had time to time raised his amount against bills through his bank account. On scrutiny, it appears plaintiff had raised excess amount against labor payment amounting to rupees 2 crore 21. In and around year 2015, and the defendant started getting complaints from the contract laborers. Plaintiff did not deposit their EPF and ECI in their account. Through the same was paid to the plaintiff. As the plaintiff was irregular in his service, his contract was terminated. Plaintiff has filed this instant suit as a counterblast of his termination, and to avoid payment of the due amount, defendant reserves the right to realize the excess payment before appropriate court of law. Then defendant is maintaining running continuous account till date of transaction.
This construction of the factory building, etc., was done by them only.
Yes, yes, part of it, my lord, which, my lord, was over by 2010, 2011, because we had started functioning.
And these unpaid bills, according to them,
relate to that contract.
That construction.
Correct.
The civil part.
The
civil part.
Correct.
The labor part is fully paid.
Fully paid.
The civil part, 24 bills,
Wait.
23 unpaid.
So civil contract 2009, they say 24 bills. We say 1 bill, we are paid. 23 bills surface, my lord, when the suit 2015. The labor contract, my lord, so far as after, my lord, the civil construction is done, quite naturally they'll supply labor after, my lord, the construction is done. That, my lord, is fully paid, which is, my lord, the case of both sides. And I'll show, my lord, those contracts as well. My lord, kindly look at, my lord, the first. So this, my lord, why I'm showing, my lord, the amended written instrument, there's a denial to their claim. Because when I show, my lord, the impugned judgment, perhaps, my lord, there's some lacuna, my lord, there with great respect, my lord, to the learned, my lord, trial court. That, my lord, how, my lord, he's also, my lord, read the written statement. Now, my lord, the first contract, my lord, will find, my lord, at page 197, which is volume 2. Part 2. Confusion. No, 197.
Labor contract. Labor contract was that. What's contract which won't be raised? Correct. It's a big time. Now, second volume. This is the contract for civil work.
For civil work. And my lord, will see very important. My lord, his work was really, my lord, on the account of earth filling, earth cutting and all that. Because my lord will see subject work order for civil work with material except steel and cement. So steel and cement, my lord, is not his job.
Yes.
For our 9 MVA into 4 Sunsarge, FAP bricketing jigging plant 132 kV and other civil works for a Barjura unit. Please to place a work order of civil work material except steel and cement. So the expensive thing, my lord, was ours only. We were to, my lord, for our Barjura plant, as per then earth cutting, my lord, sees earth cutting, then RCC reinforced concrete, then shuttering, brickwork. Next page also, my lord. Brickwork, plaster of ceiling up to 3 meter height, then water bar filling, window fitting, removing up to, my lord, item 30. Because this is, my lord, what he claims for as 8 crores. The 23 bill, 1 bill, my lord, is 1 crore, 98 lakhs and odd. The rest 23, my lord, is 7 crores. So, Malad, this is the nature of work, and Malad, very important at 199. Terms and condition, Malad sees electricity and adequate lighting arrangement site for working shall be provided by us at no extra cost. Labor hutments, electricity and water arrangement shall be provided by us. Steel pockets, insert plate and curb ankle with jug readymade shall be provided by us. Heavy machinery for earthwork will be provided by us. On chargeable basis, materials like runner, plywood, nail and casting machine, resistant labor tool is tackle will be provided by you. Steel and cement will be provided by us. Then Malad 7. After submission of running account bill, Kamalat is duly approved by a site engineer, 80% max of the payment will be released within 7 days. So nothing of this sort, Malad, so far as the 23 bills are concerned. Retention money will be paid within 15 days receipt of clearance note or certificate. Labor fooding 20,000 will be paid on weekly basis from the site, which will be debited from your account. Service taxes and deductions shall be applicable as per the rules. Now, Malad, from page 200, Malad will find Malad the other supply of labor contracts are there. We'll see, Malad, first one, Malad, is 2011.
Yes.
So, Malad, the labor supply bills are, Malad, at page 200, that's Malad 2011. Then Malad page 202, that's 2012.
Labor supply bill.
Sorry, work order. Work order. I'll show the bill. Sorry. Supplying labor. Malad will find for supplying labor to a factory. Then 204, again work order, supplying labor. This is Malad 2014.
Yes.
Now, Malad will kindly take Malad pages. Now, bills for this, which were paid, 899 own volume factor. Page 899 to 949. 899. Malad, I'll show the bills for the labor supply as well as the one bill, Malad, which we admit, and now they admit that it's been paid. And then, Malad, I'll show Malad the disputed bills. Volume 3.
This is just one of the sample bills.
So from 899, Malad, right up to Malad 949. Malad will see labor supply for production April 2011, May 2011, June 2011. And what I'm showing, Malad, is date is there, 6 June 2011. Then bill number reference is there. Again, Malad, date is there. And Malad, for 899, Malad, for April 2011, the bill is raised, Malad, on 5th May 2011. Next page 900, Malad, for May, it is raised in June. And with Malad service tax component as well.
Right. Yes.
And Malad, this is up to page 949. (949) is Malad January 2015, the last page of that, and Malad will find raised in Malad February 2015. This is, my lord, for the labor, no dispute, my lord, all this is paid. Now, my lord, kindly take page 2 39. 239. I'll just check. 238. No, no, 230 is request for payment. No, sorry, 239. 239. 239. What is it? 239. My lord, kindly see. TDS Sansach 98. My lord, sees the date 21st September 2011.
Yes.
Bill abstract invoice. Foundation Garda Sansach. My lord, reference RA bill first, and then 98 lakhs. This is paid. Now, admitted position is this is paid. Paid in September 2011.
Yes.
Now, my lord, kindly look, my lord, from page 240.
Those 23 bills.
Yes. No date, no reference number, from 240 till 261. Two 240, my lord, 261. Consistently, my lord, will not find.
At 239,
yes, sir.
This is not a disputed bill.
This is not a disputed bill.
This does not bear your rubber stamp, that seal.
No.
Seal.
It does not.
But the disputed bills, they bear
Yes,
your seal.
Yes. That is not to prove that yes. So one, my lord, which is not disputed, which is, my lord, paid, doesn't bear, my lord, my signature, the stamp. And all of these, my lord, will find, my lord, a same seal. लेबर हो तो सील नहीं
Proprietor নিজে sign
আছে
করেছে।
my lord, interestingly, my lord, the labor also doesn't have, my lord, a seal. Sorry, I just, my lord, since it fell from the court, my lord, I bill and one for lagao. Bill
Exhibit 4 series.
যেটা প্রথম বের করলাম সেইটা, যেটা
Exhibit 4
প্রথম
and
এটা মার্ক করলাম সেটা
এইটা কি আবার 216
ওটা না দেখুন, তলারটা দেখুন উপরে লেখা থাকবে exhibit document। দেখুন exhibit লেখা রয়েছে।
হ্যাঁ এখন ধরে
হ্যাঁ এভিডেন্স
সাড়ে 12টা
এক্সিবিট
আছে 5 আছে 5 আছে
কত কত হচ্ছে
5 আছে 4 আছে
আছে 5টা পরেরটা হ্যাঁ এটা 3 অবধি আছে
4 and 5 টা
হ্যাঁ
You don't dispute it with the seal.
হ্যাঁ জি এটা ঠিক এটা হচ্ছে কোড সবকটা
এইগুলো
দিন
কি?
কোনোটা দিন এইটাতে আছে।
এইগুলো এই ছবিগুলো কি?
ছবিগুলো হচ্ছে কাজ যেগুলো করেছে সেগুলো ছবি টেবিলের নম্বর
সবকটা নেই তো।
এগুলো তো ওদের ডকুমেন্ট সবকটা কালেক্টিভলি না জাস্ট পুরো এনটা এইখানে তুই দেখবি লাস্টে লেখা
ছবি দিয়েছে সবগুলো।
হ্যাঁ প্রত্যেকটা বিলের সাথে আছে
এরকম ভাবে কি করে চলে এলো?
কালেক্টিভলি করে ফাইলটা পরে দিতে আর দাদার কাছে থাকবে আরেকটা আরেকটা file।
আরেকটা ফাইল আছে দেখুন এক্সিবিট 5 আছে
উপরে লেখা থাকবে
এক্সিবিট 5
Paint.
Banerjee, we'll come back in 5 minutes. Usual midday.
Yes. Malad, huh? Malad, after 12:30, Malad, can I be? Please, Malad.
possible tomorrow
Tomorrow this bench is not available.
Oh, তাহলে?
এটাতে তো শেষের কথা
টাইম লাগছে
No one wants to, Malad. Both sides, Malad, they don't want to, Malad, finish it today. Including, Malad, my side and this side.
No, we'll sit again next week. That's the
Malad, then we can.
we'll sit again next week. So you want to
Because-
continue till 12:30 or you want to stop now?
Malad, we'll stop now.
Stop now. Dekho.
I personally wanted, Malad, but it seems, Malad.
personally you want
Banerjee sandwich between Chatterjee and Mukherjee.
Yes, Malad.
the vanity says surely
Malad, it is like that. Mukherjee, Banerjee, Malad, Chatterjee.
already been called twice from the back I know that
Mr. Ratnanko Banerjee, learned senior advocate representing the appellant oblique defendant, begins his argument but does not conclude. Paragraph. On the request of Mr. Banerjee,
কি নতুন
let this matter stand adjourned and be listed again on we'll keep it on Tuesday. ডেটটা দিয়ে দাও
22nd
22 দেখো এমন জায়গায় দিও যাতে এটাই টপে থাকে ধরে নিয়ে কি তো এটা একটু দিয়ে দাও তবে এটা নাও কৌশিক
18টা বলো
Malad, is it? No.
No?
Not it. No, both. Malad, we'll start, Malad, with Malad, the very bright seals of Malad, Sonic Thermal. Very bright seal, Malad, since Malad.
that's meant for you.
Malad, 11 years, Malad, it's not faded at all. Made in 2011. 2011 হয়েছে।
এই বইগুলো নিয়ে
Great.
90 days. Hearing for the respondent.
Four. কেউ ছিল না আগের বারও? Nobody was there in the first call. It has to go. We have a formula. Let them file a. We know how to deal. Usual appearance of Mr. Shah.
This is the reason we have not 15 adjournments in the section 11.
ঠিক আছে না না
My lord, the appeal is against an order dated 10th March 2025, by which, my lord, in a testament, my lord, I'll just indicate it was passed in a testamentary proceeding, my lord, for complying with the provision of section 283, subsection 3 of the Indian Succession Act. That is because one of the properties was situated outside, my lord. Now, this was passed on the basis
Justice Arindam Mukherjee.
Yes, my lord. The next matter which is fixed, my lord, that is same, my lord. That is the appeal from the principal order. My order was passed on the basis of this 16 January 2025 order, my lord. Kindly seize, my lord, the order impugned dated 10th March 2025. Now, on the same point, whether 283(3) is mandatory or not, my lord.
No, no, order to দাও না
Memo of appeal ta din ekbar.
আর এটা ইন্ডিয়ান সাকসেশন অ্যাক্ট বার করে তো
It is appearing under the heading application, but my lord, because there is a delay of about 90 days in filing this appeal. So, my lord, I have taken out an application for condonation of.
This is what, but this in the goods of Prabhi Chandra Sen has been appealed against.
Yes, my lord. That is the next matter, I believe, which is fixed at 3:15, I think.
Oh, I see. Then let us adjourn this matter.
My lord, we'll kindly condone the delay.
Yes, that we will.
My lord, 90 days delay, my lord. There was a delay in payment of the folio charges for which, my lord, we couldn't file the appeal within time.
কি যেন ছিল প্রভিশনটা ভুলেও গেছি 283
Indian Succession Act
That is the matter fixed at 3:30 আজকে
3:15, ma'am.
হ্যাঁ that's right
কি হয়েছে না 15 আছে ওটা
I see. Wait, what the which one? GA?
One.
GA1, my lord.
GA1 টা নাও GA1 এর উপর একটা অর্ডার করো This is an application for condonation of delay of 90 days in presenting the appeal. The causes shown being sufficient, the delay is condoned. Paragraph GA1 is disposed of. Then appeal ta now, APOT ta de lekho. Let this matter. Now, since the point involved in this appeal is under our consideration in another matter which we have fixed for hearing today itself at 3:15 p.m., comma, let this matter stand adjourned for the week. Let this appeal stand adjourned for the week. এই জিএটা disposed of হয়ে গেল।
I'm extremely grateful to him.
Order. Old matter. Item number 3. I've submitted my report.
Huh? Item number 3.
Yes.
দুটা হবে না কেন? কি দেখছি আমি ভুলভাল দেখছি তাহলে। এটা কি এটা কি নন কমার্শিয়াল হচ্ছে? ও আই সি, তাই ভাবছি মিলছে না কেন হিসেবে। ইন দ্য গুডস অফ তো নেই, কমার্শিয়াল একটা অন্য কি আছে? আই সি। Oh, yes.
My lord, there's an order of the division bench passed by Justice Chellur and Justice Bagchi way back in 2015. Certain things had to be done. Now, my lord, I will only show you the order of the Supreme Court, because after about 2.5 years, ultimately, initially Justice Narayan had the occasion to, when it was prior to the vacation. When we moved it, Justice Narayan.
Justice Rai.
No, it was first before.
Justice Om Narayan Rai. Not Justice
We all know by the first name. First two. So
maybe.
Right.
But
Yes.
not in a court.
Yes. I'm sorry.
Yes.
I thought, when your lord was saying,
yes,
saying
right.
Yes. So I got a little.
So in a nutshell, this company went into liquidation. Sharad Chatterjee, no.
No. I am Sharad Chatterjee. I am the clearing agent.
Oh, sorry.
Goods. The company, my lord, that's not the point. The point is all this, my lord, please see the order of the High Court and the order of the Supreme Court. My lord, what the Supreme Court directed and why it is being delayed. That is the only thing, my lord, your lordship has to see. Now,
it is the direction is for sale of the.
Right. I tell you what happened in the Supreme Court. You see, as it happens, bidding before Justice Matre, presided over by Justice Matre, this matter was taken up for hearing because one person bid a particular amount, about 14,500. Now, per metric ton. He was not allowed. He wanted to withdraw. Later on, it transpired that the person who had bid was bidding just on the value without deducting the tax, customs duty, etc. These are not duty paid goods. So if you deducted it, it would have fallen even below the reserve price. That is the ground on which it was set aside. They said you should have allowed the other person to come and bid, which was a higher price, without the customs duty he was taking. So you shouldn't have turned it. So my lord, kindly see the direction of the Supreme Court.
Sure. Where?
Yes. My lord, there's an application.
Page number 35 starts.
Yes. My lord, if you please first come to the High Court order, then I will show you the report.
Impugned order.
No, there's no impugned order here. I am filing way back in application disposed of. I am only citing in interim order.
I see.
Modification, my lord, something has to be done, my lord.
Yes.
Yes. My lord, page 25, if you see, my lord, kindly see what is the direction of the High Court first.
Now it says it appears from the pleading submissions, status of the is as follows.
Page 25, yes.
Yes, that's part of Justice Chellu's order, bench presided by Justice Chellu and Justice Bagchi, way back 14. This is the main order, my lord. Under which, has your lordship found it?
Yes, it starts at 19.
Yes, my lord. But for many things are there, I did not go. It appears from the pleadings and submission of the parties, status are as follows. Goods lying at R5 go down, for which duty has not been paid. So, my lord, 6250 metric tons. Someone has to pay the duty.
This is what, customs duty?
Yes, my lord, it's uncleared goods lying in my, well, sort of bonded, my lord, without that territory. Then it says, part of it, R5 in respect of which duty is paid. So I say, I am the collector, my lord, someone has kept it, 931 has been paid, and the person who has paid the duties are, sorry, that's the appellant is saying, which has gone into liquidation. Now, my lord, I say, no, actually 793 point, my lord, has been paid. That's a question of fact. Then we are not concerned about the second one, because direction is not on the second one. And the third one, R1 at Ripley go down, my lord, it is 471750. Also duty not paid. Right, my lord? So, my lord, we are interested, the direction is to sell only 10,000. He is claiming interest of 10,000 metric ton only. So, my lord, you will find 6250 plus 471750 will be more than
11,000.
More 11,000. And whatever duty is paid, so kindly now see the direction. My lord, out of the said consignment has stake claim of 10,000 in possession, title, namely such as such. Issue is whether the goods 10,000 has been sold to Bala, etc., etc. Now, my lord, kindly come to page 26. 26. We are also of the view, has your lordship found it, that vagaries of the market, likelihood price going down, to avoid further escalation, demurrage, it would be prudent to sell, SELL, 10,000 metric tons out of the remainder to secure LMJ. Appellant and R4, that is the part of the Concast group, shall be at liberty to take delivery of remainder after clearing port charges thereon in accordance with law. Now, my lord, the question is, in this backdrop, we are of the opinion that a special officer be appointed to inspect, make inventory, take steps to sell 10,000, where lying only at R5 and Ripley. Sale price of us after clearance of customs shall be deposited. Who will keep it? Appellant will be at liberty to take delivery of remainder stock after clearing port charges, if any, in accordance with law. Then, my lord, about my handling charges, etc., I will file a suit, etc. So, absolutely clear. My lord, the order is clear that you can't allow the goods, someone who purchases the goods has to file bill of entry, and then customs would be assessed, you pay customs, so a price has to be quoted. Just sell it. Now, my lord, when it went to the Supreme Court after the order, this is the order which was passed. Page 47.
This order was carried to the Supreme Court by who?
My lord, it was not by us. My lord, the Supreme Court was carried by, my lord, the LMJ itself. Because LMJ, my lord, when the sale was confirmed, my lord, kindly come to page 29. That is, this was carried. Now, my lord, what happened? A person came and bid a higher amount and said, you can't come like this at this stage. Deliberate stage thing is to delay. And he was not allowed to bid. That was the order on 29. It was confirmed. Whoever had bid the highest, my lord, the court said, my lord, Well, Miller, I'm not here to comment whether it was right or not. The Supreme Court has set it aside because the appeal was preferred by LMJ, saying that, look here, you could have, Miller, you could have got more value for the 10,000. So you deliberately did not allow this. So this should be set aside. So that was the contention. So LMJ preferred, and this is the order, my lord, which was passed at page, my lord, 35. My lord, or rather, my lord, I've told you why it was set aside. 47 would do. My lord, para 14. My lord, may I read it carefully? It is clear that value of met coke is much higher, which gets substantiated by the valuation report, and maybe for this reason came forward with much higher offer of such an exclusive of taxes. So this gentleman who was thrown out, not allowed, said, I will give 4,000 exclusive. Now, my lord, taxes is about 5,000 probably metric ton.
He was thrown out by whom?
By this court. They're not allowed to by the appeal court.
Why?
Because, my lord, it was terms and conditions. He did not participate and all these conditions.
I see.
And he came subsequently when it came for confirmation. That is why, my lord, thrown out. My lord, court sale, it is happening. Then, my lord, my lord, or rather 13, the person who had bid 13,000, my lord, that was supposed to be confirmed. It matched the reserve price. It matched the reserve price. So it says, if I deduct customs and all this, it comes to 8,000. So you couldn't. That is the reason. You couldn't throw out this person. My lord, though the High Court was right in rejecting the offer on this fact emphasized, goods in question are capable of receiving. It would therefore be overall interest of parties to have fresh auction. That was 2,000. We, my lord, please allow appeal, set aside. Special law is directed to get valuation done, my lord, again, my lord, kindly see, so that present day valuation is ascertained, and on this basis, inviting bids in question be issued with clear stipulation that reserve price is exclusive of taxes. My lord, if it is possible, ascertain the exact amount of taxes will be indicated in the part of order to take a clear picture, if it is possible. Now, my lord, 3 times the valuation has been done. I have contributed. I said I want to get it out. I am willing to contribute 3 times.
The go down is yours. Go down is yours.
Yes, hired from the port. I am going on, my lord. It's phenomenally high now. It's going on. A whole port go down is blocked. That is why it said you go on. Well, 2 things I will say. Remuneration, I was not directed to pay of the special officer. They were to be shared by LMJ and Dankuni. But because I am trapped, I want to pay and without prejudice get it recovered as first priority and remove it immediately from this go down. So that the port charges also do not, and they are imposing 10 times. That's the law. You cannot keep it like this. Demurrage in the tariff and all, it gets, Millard, no, please. Now, what has happened, Millard, in this matter? It is 2018, pandemic, and now 2001
No, when did pandemic come? 2020.
My lord, I will show you what happened first. It said, first notice was given to customs. And first I had to clarify, I was called upon to clarify how much are the customs charges. I said, how will I know the custom charges? First, someone has to file a bill of entry and then ascertain the customs charges. But yet, we provided some detail, the port charges to the special officer, completed in 2018. Then says, no, you ascertain from customs. The customs was not responding. Then customs also responded, said, this is the approximate charges. Then we got the charges for 6250. He said, no, now you ascertain, my lord, for 10,000 metric ton. He said, how will I ascertain? Unless a person files bill of entry, because it says may, if it is possible, then you fix the price accordingly. The price which has to be direction of Supreme Court is exclusive.
Yes, but then Mr. Bose, if for 6,000 metric tons,
yes,
the quantum of customs duty
it will go on changing every time. So that is what is being done now, my lord. Every time over this side, once in a side, then one said, no, it has been a long time. Now you see how much goods are there in your go down. So 200 metric ton, about metric ton came less. Someone was engaged. I paid, said, why is it less? I said, maybe how is it possible to exactly measure? Once it goes out, then it will be measured in weighbridge. And over the time, if it's coal, some of it is already becoming dust. But what am I supposed to do? If it is less, anyway, 10,000 is there. Get it out. My lord, this is one. 3 times valuation has been done. 3 times over the years. Well, the time has passed, pandemic has gone, now another valuation. 3 times I am side, the company in liquidation, then they went into liquidation. This LMJ said, so sorry, it can't be done. The suit is gone. Now they are in liquidation. So for that, again, a clarification had to be given, my lord, from the court that he has to act. And every time the advocate and record goes, once a counsel was engaged, advocate and record said, please get it rid. Please, we are suffering. We are suffering. You can show the list of the dates.
2024
yes.
Last year.
Now, my lord, up to 7 November 24, we gave the dues of the port is 7 crores. Has already more than 7 crores. I can't do it. It will go on increasing. My lord,
you suggest what we can do.
My lord, please, two things. Now, my clients, if it's a question of money, remuneration, I said, my lord, my clients will pay for whatever is right, but from the as first priority from the proceeds, first get that remuneration bit out, and then, my lord, I think it is impossible. If it is not possible to say what customs duty, you can only fix a tentative customs duty and tentative cost. So on that basis, the terms that twice terms were all agreed. Parties agreed in 2000. Terms were settled. Then, my lord, people they cited no. Terms may be agreed, but ascertain the customs duty. My lord, there is no mandate to ascertain customs duty if it is possible. If a person doesn't file bill of entry, how is it possible to ascertain customs duty? It will be ascertained then when you file bill of entry. So that's why Supreme Court is conscious. Says if it is possible, if you are tentative, my lord, and keep a very low figure, because the valuer, last valuer, has suddenly says, remember before, it is now 32,000, the value of this coal. Now 32,000 per metric ton, which was 14,000, has the valuer has said 32,000. We said, if you
gone up.
Yes, coal. Prices are increasing. My lord, no, that's what the valuer says. My lord, I am not saying I paid my part of remuneration. My lord, I feel, if you ask me, you advertise, no one will come to bid that amount. It was 14,500 then without taxes in 2018. So initially we all agreed that that should be the cutoff limit. And you say exclusive of taxes and finish the matter in 2018. That's what was agreed. Terms exchange. It didn't happen. Now, my lord, because of everyday valuation, these valuers also, it may not work out.
The last valuation was done when?
Just in 2024. 24. I don't think, my lord, if your lordship is asking me as a counsel, I don't think it is a realistic value. And valuers, it's well known.
So then on what value shall we proceed?
My lord, your lordship will...
6,250 is outstanding.
Yes.
And the customs duty is only
So,
balance.
They are a very renowned valuer.
My lord, maybe you are a valuer. I don't know. Many renowned valuers may come, side. My lord, your lordship will decide a say for example 20,000. 32 is too realistic.
How can we arbitrate? It will become arbitrary.
So, my lord, there are 3 valuation reports.
Yes.
Now, which one, my lord, will you?
At 3 different points of time.
At 3 different points of time.
When was the first one? Tell us.
My lord, first one, my lord, immediately. We in 2000
the order
18
was,
after the order. My lord,
order was division bench order was 2015.
Yes.
July 2015.
Yes.
First valuation report is
My lord, I am not carrying.
No. That has gone. So it was direction about the Supreme Court to again revalue. So
when was that done?
2018.
18.
Yes.
What does that valuation report
My
say?
lord, I think 14th. It's written in the list of dates.
Where is your list of dates?
Yes.
Hey.
No, not list of dates. This report is list of dates.
Oh. Report the file.
My lord, I'll just tell you. I marked everything.
7th of May 2018.
আমার এটা গেল কোথায়? আরে আমার তো মার্ক করাটা। Yes, sorry. Yes. Prepared. My lord, kindly come. Page 5, 7th May 2018. So 21st, 21,500, excluding tax. If you add tax, if you want my thing about it, it will be another 5,000 or 6,000 odd. So that's what the Supreme Court held, because 13,000 minus something came to 8,000. My lord, is noted in the Supreme Court order. So I am taking about roughly 5,000. So 21,500 plus 5,000 will take you roughly to 26 or 27,000. Now they say 32,000 exclusive. This is the recent. Will fetch, may not fetch. But suddenly 21,000, so something is there, 21,500 excluding tax. People will
Tell us another thing, Mr. Bose.
Yes, my lord.
Which other party has any stake in the sale proceeds of this 10,000?
My lord, the company in liquidation, that is, there is Dankuni and Concas, which is defender number 6, which are all part of the Concas group. And my lord, once an offer was made by LMJ. What will you have gone to liquidation? Let me get your goods also. So
why we are saying court cannot decide on the reserve price?
No. The reserve, because it has to be fixed. That's the and that is the fight about. And I can't help it. Someone has to decide.
Why we asked you which other parties would have stake in the sale proceeds if those parties together can agree on a reserve price?
We will never agree.
My lord, they are not. That is the problem. And says meeting after meeting after meeting is happening because what are your comments? What are my comments? Huh? I mean, I can only give you the port charges. Is it possible for the clearing to give the, if I may ask to myself this question? So, my lord, I don't know where we stand, but someone, as your lordship, you will not determine, you are not the special officer. Let's face it, my lord, you have deputed a person and you must do it. And all I can pray is that person is an officer of your lordship. And lordship can only monitor what he does. So I am, today as a council, I'm saying it was fixed at 21,500. It is more than 14,500 as per Supreme Court. Do it. May not finish this matter. And that should be the direction, face accordingly.
ওটা বলেছিল 2022 45,000 মেট্রিক টন ওরা রেজ করেছিল in 2023 সেটা থেকে আবার প্রাইসটা 35 something
May I say one thing, just one more. Page 37 of this report. Why this, your lordship is saying, let them decide on the reserve price. This is the problem. Page 37.
we are saying it will be 45
12/22. Immediately after pandemic, everyone has woken up. My lord.
Who is respondent number 2?
That is LMJ. They said fix reserve. So we protested, saying if you fix, no one will come.
45,000.
Yes, and randomly everyone. And then again saying, oh, something has gone. Now you wait. My lord,
we'll tell you what we are going to do.
my lord, whatever, my lord, please.
Fine.
Please
We will
don't tell me. You
Okay.
do whatever.
We will not tell you what we'll do. But have you been able to obtain any idea about the customs duty?
Yes, we have said.
Where is that?
My
Where shall we find that? That should be indicated.
lord, we have done it on the basis
customs
the customs had sent a letter. My lord,
We'll start the ball rolling now. It's high time.
my lord, it is short matter. It will be completed in 3 months.
Yes.
My lord, keep the matter pending. All I say.
No, we are not disposing of.
Yes, please. My lord, just see, this is a letter given recently because they were not answering. My lord, initially they had indicated something in 2019. Again said, you again inform. 3 times customs, and why should they respond? They are not parties.
So 3.47 crore.
It's a key on what?
customs duty ওরা জানিয়েছিল
On how much quantity? 6,250. This is only on 6,250.
the amount which is only outstanding. Balance is paid. Only customs duty.
অন্যটাও paid.
খালি এইটা 6,250 বাকি আছে।
See, I am told, Miller, for the balance, even the other, which I was thinking, which I said may not reply, that also he says, my lord, it has been paid.
It is issued.
My lord, apart from this, there is port dues on the go down, which also had to be cleared. Port
dues, why will the purchaser?
Yes, that's the order of the division bench. That is.
It may come out of the sale proceeds.
Yes.
The purchaser will have to pay the port dues.
Yes, yes, you are clearing.
They are
No,
to be,
you are clearing the person, removing.
we have been paid.
But the division bench order has been set aside.
No, no. This order has been implemented, reiterated by the Supreme Court. Mela, kindly see.
29 July stands.
Please, one by one, please.
Yes, yes.
So this is the customs.
Yes. Yes.
Where is the latest valuation report?
That is in 2024.
Where is it? We want it.
Oh, acha. Do you have it here?
Is it not a part of your report?
No.
It is not the part of the report, but I have got it.
Why not?
Just one thing to clarify your lordship's doubt. Yeah. Sorry. Yes. Page 26.
That is on 6250. They have to explain the balance one. Otherwise, how will
That's the only portion which
is outstanding.
remains.
10,000?
Rest we have paid.
Other balance portion, the duty has been paid, Mr. Mukherjee.
We have to recover that money from that customs duty. From the
Don't break your head over it.
Please,
Let us take charge now. Enough time has gone.
Page 26. Page 26. The appellant will be at liberty to take delivery lying after clearing customs duty and port charges.
Page 26
of this application.
This is a letter.
No, page 26 of our
26.
application.
Your lordship is looking at the report.
Oh, I mean the report they see.
The appellant and or R4 shall be at liberty to take delivery of remainder of stock lying in the godown after clearing customs duty and port charges, if any, in accordance with law. So, my lord, and we have proceeded on that basis. We have proceeded on that basis. My lord, this much I protected my client, my lord. That is why from time to time I have been asked to furnish how much are the port charges. That is why I am being asked to furnish details. That is why from 2018 I have been asked to furnish what are the calculation, and they are asked to give their comments. And comment is taking long time. They are not giving comment. It's not a site adjourned meeting. This has been going on.
When can you give us a copy of the latest valuation report?
Immediately in 10 minutes time.
Yes, give us that.
Copy.
No, don't run. 2 o'clock. Give it to us at 2 o'clock. Don't make him run. He's not growing any younger.
Oh, he fell down. I made him run once. He was, I was sitting in upstairs Bal Library Club. Then he says for 6 months, because I suffer from hypertension. So he said because of me, he suffers from more hypertension. So he fell down and it fractured it down the staircase and fractured his psoas. After that,
তুমি কি করছো বলেছো 2 PM রাখছি না না
Oh, 2 PM বললো? Oh.
2 PM রাখছি 2 PM নিয়ে আসছি
Malad, in between the two valuation report, there has been another valuation also. If you, how many does it?
Give us all the valuation reports.
All the?
Yes.
সব দিয়ে
Mark the portion we only need to know
the exact
rupees such and such per metric ton. That portion please mark so that we don't have to go through the entire.
I was humbly praying. I mean,
Yes.
subject to what
Yes.
was Malad, my lord, my lord, if
Ideally, there should be another valuation.
my lord, fourth, this is exactly what is being.
Because once we get it done,
My lord, because then
we will tell you why. My brother was just pointing out the Supreme Court says present day valuation.
Present day valuation was done. It was 40.
It is no more a present day valuation. This is what we are saying.
So why, Hama?
Now, Mr. Bose,
I have not made the present the past.
Mr. Bose, we are taking it we are taking charge now. Present day valuation notice will be published within a month. The process has to be completed.
When a valuation
6
will
weeks.
take at least 3 months.
3 months.
15-20 days. Then the question about
challenge করবে ওরা আরেকটা বলবে ভ্যালুয়ার অ্যাপয়েন্ট করো they will take
my lord, every
Which month of 24 the valuation? Remember?
24
my lord,
August
my lord, I am humbly praying, my lord. He is quoted 32. The value.
Mr. Bose, please understand. We cannot say 25 arbitrarily. We have to try with 32. If nobody comes, we'll take the next valuation report. Otherwise, it will be arbitrary. We have no special expertise in this area. We have no idea.
Oh, obviously. Now, only thing is, I never agreed to 32. And the question again comes, who will pay for this new valuation? Technically speaking, it was all upon now the other person. I do not, my lord, I do not want anyone. As long as
we will go by, give us those reports at 2 o'clock. We will pass order next week. We'll pass order next week. We'll discuss in chamber.
If your lordship feels since it fell from, I don't want to. It's not that I don't want to do a valuation. If it's a question of money, because I believe last time they charged about 35,000. No, lakhs, not 1,000.
35,000 rupees.
For valuation.
For valuation,
it is nothing.
I don't know. It's nothing. I don't mind. My client, I don't want anyone's help now. As long as I get it in priority before it, but I am willing to expedite the process, and whatever direction, if it falls from Justice Rai, yes, you have to do, I will do it.
Very well. Very well. Then let us
You
pass
want
that order
anything,
today.
please. Sorry. Yeah.
Get evaluation. Shuto? আগের দিনের অর্ডারটা কোথায়?
And if your lordships want an independent new, please, it will be your lordship's choice.
For valuer.
Valuer?
Yes.
Where from?
Otherwise, both parties.
No, my lord, every time this is happening. First to choose the valuer, this is leaves it to the if your lordship wants. But if you
পার্টির উপর ছাড়লেই আমরা যেটা বলবো তার মতো বলবো
Very well. This will be listed again. You give us the report today.
Yes.
Listed again on Wednesday.
Yes, my lord, since it has fallen from Justice Rai, please make it parted. Anytime you fix, because it fell. I don't want to be a contender. Please make it before this, and I beseech your lordship, Justice Rai, to make it your one.
Will not be necessary. We can't tell you more. It may not be necessary to make this parted. We have heard Mr. Bose, learned senior counsel, appearing for the respondent number 1 at some length. Stop. Paragraph. The matter of sale of 10,000 metric tons of met coke lying in the godown of the respondent number 1 hired from the Kolkata Port Trust authorities. Huh?
Visakhapatnam.
Oh, sorry. So from the Kolkata Port Trust, Visakhapatnam Port Trust authorities, has been pending for a very long time. Stop. The order of the division bench in this regard was passed on. Division bench of a coordinate bench. Order of a coordinate bench in this regard was passed on July 29, 2015. Stop. The Honorable Supreme Court set aside that order.
No, that order was not.
No,
No,
not that order.
which order?
Miller, the sale order, which was subsequently.
Oh, I
That
see.
is 15th
Ah.
May 2017. Because there was a direction to sell.
My lord, this order was set aside. This
15th May 2017.
My lord, 15th May 2017 was set aside. Page 29.
What is the LNG or Conca?
My lord, page 29 was set aside.
Or Conca. Mr. Bose, the division bench order 29 July 2015 says that the appellant, which is Dankuni or Concast, are 4.
Same Concast group.
Hmm?
They are part of the
Maybe,
Concast
maybe.
group.
Will be at liberty to take delivery upon clearing the customs and port.
Right.
This is what we are wondering. Why should the purchaser pay the port charges?
My lord,
Why should the purchaser pay the port charges?
They were not paying, we have paid.
My lord, it's
It may come out of the sale proceeds. That's one thing.
that's my lord,
That
it's
is
written.
subsequent, 29.
I showed your lordship, my lord.
29 July 2015.
My lord, page 26.
Yes, appellant or
Yes.
Concast.
Yes, after clearing. My lord, even before. Yes, yes. My lord, the sale, just above that. The sale price of aforesaid after clearance of customs duty and port charges.
Correct. That's what we are saying.
Right.
It will be come out of the sale proceeds.
Of course.
Therefore, we
My lord-
can't foist that liability on the purchaser.
Oh, no, my lord, I'm sorry. Because when you fix the price of sale price, this is taken into account. That's all. No, your lordship was thinking I'm foisting on the.
Yes.
No, the price which the person is quoting will be. That is why it said the Supreme Court that if it is possible, also quote this price and include it. So that
Customs, that's
that
customs.
yes.
Customs.
No, only customs. Also the port.
Supreme Court doesn't talk about the port at all.
Oh, okay, sorry.
That was only
Ah.
customs.
Hey, you will them?
47. Charges and taxes.
My lord, it says
Charges and taxes.
charges and taxes.
Charges and taxes.
Charges.
Because I remember including this in this port charges.
How much is the port charge now?
About
2024,
24, 31st
in
March.
20,
was
on
7
31st March
crore 6 lakh.
24, it was 7 crore 6 lakh.
Point is, as soon as you indicate that in your notice, nobody will come.
Correct.
That is
So,
why
my
the
lord, that
person
is why.
person
So,
should
when you
also
fix the
sell
price,
tax.
like you're fixing 30, 40,
35,000.
We will
35,000
go by the latest value. Now we are trying to get a new valuation.
new valuation. So,
Give
so,
different
so,
valuation.
so, my lord, our case, when we wrote a letter, we said there is one document that everything is, where is this letter? We said this is what has been quoted by this valuer of 32,000 or 35,000 includes everything.
Yes.
That is what our letter says. When we said, what's your comment? Way back, I mean, again, 5 months back, that it includes everything. Don't again impose, because if you 35,000 say plus 5,000, 40, no one would come. Well, not have I been able to? কোথায় বলেছি যে
Stop.
it includes
The order of the Honorable Supreme Court setting aside the sale that had been confirmed in favor of, sale was confirmed, remember?
in favor of
In favor of the highest bidder, comma,
নামটা কি বল?
not necessary.
Yes, Tycoon Suppliers Private Limited.
Not necessary. You will know the order of this.
That has been confirmed in favor of the highest bidder.
Was passed on December 14, 2017. Stop. As we have recorded in our order dated June 12, 2025, as we have Nakaru, as a coordinate bench, as recorded in the order dated June 12, 2025, the Honorable Supreme Court directed the concerned coke to be sold in a fresh auction. Stop. Paragraph. We are told that there are several valuation reports. Stop. Nah, comma. The last of which was prepared sometime in the middle of 2024. Stop. We request learned advocate on record for the respondent number 1 to file copies of all the valuation reports that are available till now. Stop. Paragraph. We are of the view that a fresh valuation report should be obtained so that the auction can be held on the basis of present day valuation of the goods. A purota inverted comma as has been directed by the Honorable Supreme Court. Stop. Paragraph. List this matter once again on Budhbarer date diye dao, comma, retaining its position when we shall pass appropriate directions for fresh valuation. Today you give us that at 2 o'clock.
It will be given.
And you can walk, don't run.
My lord, another thing, the valuer, it's up to your lordship, I think should be directed that whatever he's quoting, is it inclusive of tentative? No one can determine what the exact customs duty would be. No one can. It is fluctuating. And the other, it says taxes and charges, whether it includes all taxes and charges. Otherwise, my lord, the confusion remains.
Mr. Bose, we will dictate the order in front of you.
No, my lord. I'm just indicating, my lord, all this, because this is the thing which is...
We are trying, before Wednesday, we will ascertain from our registry if we have any such competent valuer on our panel. If we don't have, then you will have to give the name.
My lord, panel valuers, this is...
A civil engineer cannot go and value this.
Specialized.
Therefore, let us find out. Met coke, na? Met coke.
My lord, does your lordship require any names?
Yes, you also come back with names. Or give us, if you have names, give us.
My lord, I cannot trust my client, because if I had known whether they're competent or not, your lordship will accept.
Come back with names. If we don't have impaneled competent people, then what we'll have
and
to...
this is in, of course, Orissa, all the way. Visakhapatnam.
Oh, Baba, Visakhapatnam.
So that is also a problem. And valuation of coke.
Specialized subject.
It's quite special. Specialized.
Companies has done the valuation, my lord. They are from Vizag only. That I have inquired and got.
Parties had not given.
So why don't we get a fresh valuation
The one
through the same party which did the last one?
Did the last one?
Last
In
one.
their presence, it will be done.
Sending somebody on our খালি মনে হচ্ছে
এটা তো বেশি।
45
কষ্ট বেড়ে যাবে।
35 টা is you think আমার তো মনে হয় 21 বেশি হবে না।
My lord, subject, my lord, the person who had quoted, which we all accepted, if that person could do it.
Which person?
The 21,500, which was agreed also.
JB Boda.
JB Boda, so no, my lordship, JB.
That is the, where is he stationed?
Last
Vizag.
দুবারই কি JB Boda?
একবার ভাইজ্যাকের
And
JB
one
Boda
Alex,
করেছে।
once Alex Stewart.
Alex Stewart-এর against-এ JB Boda-র দুটো রিপোর্ট আছে।
Mr. Miss
Alex Stewart কত দিয়েছে?
Ghosh, Miss Ghosh, we'll come back all together on Wednesday. We'll dictate the order here, sitting in court, so that he can all give us inputs.
I'm sorry, just there are a few names. JB Boda, Alex Stewart, Norman Stewart, all these are in the shipping trade. These are common names. We are all aware of. So I mean that's why I said fresh valuation has to be specialized.
Accepted by both parties, তাই জন্য JB Boda বললাম।
এই কি 35 কে দিয়েছে?
এই দিয়েছে
Alex
JB
is
Boda।
অনেক বেশি।
Alex 45
But I'll bring the
বুধবার এসো, বুধবার এসো।
I'm sorry for not mentioning your surname correctly. We all
JB Boda was accepted by both. I mean, JB Boda was
My lord, in this matter, a settlement is going on between the parties, my lord. 7 and 8, my lord.
accepted ছিল যার রিপোর্ট।
My lord, we only will be praying for some time, my lord.
7 and 8.
7 and 8, my lord. My lord, 7 I am for the appellant and
8 I am for the appellant.
he's
এসে বসো আর going on.
আচ্ছা আচ্ছা, very well. 7 আর 8 একসঙ্গে হচ্ছে নাকি এগুলো না?
my lord, yes, both were taken together, my lord.
Separate orders. লেখো আলাদা করে অর্ডার করবেন। Learned advocates for the parties jointly submit that talks of settlement between the parties are in progress. Stop. On their request, let this matter stand adjourned for
My lord, September, my lord, month.
September.
My lord, this is with regard
Stand
to
adjourned and stand adjourned and be included in the monthly list of September 2025.
Grateful.
Same order in 7 and 8. Separate orders, but 7. Thank you.
Grateful one.
And my lord, kindly, my lord, to mention this appeal, my lord, which is specially assigned to your lordships, my lord. This bench, my lord, if it could be, my lord, fixed, my lord, adjusted with the order. This pursuant to this order, my lord, this order records, my lord, when your lordships heard this, and thereafter, my lord, pursuant to this, it has been assigned to your lordships, my lord.
This bench.
This bench, my lord, this assignment is here, my lord. This
Tuesday, appellate side.
Original side.
Non-commercial.
We are for the appellant.
Commercial. Commercial. Don't keep it on Monday. Monday is very uncertain in all sorts of ways. Tuesday.
Your Lordship, second half time may be
Let us
fixed,
see.
Your Lordship.
A lot of things may happen.
No, my lord, that has already happened. My lord, your lordship, my lord, I have it, my lord, your lordship is not still heading the same bench after Tuesday as well.
With whom?
Same bench. My lord,
The determinations have come, Your Lordship.
they've come. At least they're on public.
From the 18th. From the 18th. It may again change. We'll have another.
But no, this will not change. This will be heard by your lordships only. No, this is
Yes,
assigned.
partner. Of course, correct.
This is not assigned to your lordships. No, so this will follow wherever you. So not,
Let it be listed on Tuesday. We'll take it up from there.
I'm grateful to your lordship. Tuesday, thank you.
Your Lordship will be
Team
hearing us. We are the appellant, Your Lordship. We were arguing. Mr. Lahiri was.
They had almost concluded. No, I think it's 1 day submission.
The Vikramjit Banerjee, the learned ASG, wanted to, Your Lordship, so Tuesday it may be fixed. Thereafter, I'll take instructions when the learned ASG shall be available. And
I
thereafter,
think not,
Your
this
Lordship.
not has been
Because
going on
today,
for months.
today,
now,
12:30 or 1, the notice was served, so I could not take instructions from him when.
Have sufficient time now. It will be listed on Tuesday. You have 4 clear days. Tuesday it will be listed. If it is taken up, whichever party is there, we will hear that party. We have spent a lot of time on this matter.
Your Lordship, we just conclusion is to be left.
Yes, madam. They've almost concluded. Not we were to start once. Not they finish.
Okay.
We have dismissed the appeal.
Lord, I had told my learned friend Lord before election. Not I had said this is going to happen, and I also told her the reason why.
We were discussing who is going to laugh at whom. But this has
My lord,
actually
only one. My
personal.
lord, only one request. My lord, the entire amount is lying deposited with the registrar. My lord, may they not proceed with the execution. But I'll not ask for a stay. But let them not proceed with the execution for 2 months. My lord, we shall not take our chance. My lord.
This man, the whole idea was to
No,
do.
the amount is lying deposited. My lord, the entire amount is secured.
No,
There is anyway a bar, isn't there, in law? 2 months against the government, you can't proceed in execution.
No, I don't know how it will be interpreted, my lord, because whether it is from the date of decree or whether it is from.
So either you make a formal prayer, what?
Yes, but I'm praying first time. I'm praying first step. The operation.
they're not 2 months.
After delivery of judgment, comma, learned advocate for the state, prays for stay of operation of the judgment. Your 34 was dismissed.
33 was 33 was dismissed. Yes.
So what will it revive?
My lord, the stay, my lord, will ensure that they can't proceed with execution. My lord, it will mean not my 34 appeal is pending, which is a continuation of proceedings. So, not it's automatic. If the proceedings are continuing, but the stay is automatic. So,
First court, my lord, they lost, and there is a particular amount, my lord, which is there. The registrar has, my lord, given a.
yes, that amount I'm not withdrawing. That amount is like yes.
Not while during the pendency of this appeal, I made an application, my lord, under 14. There, my lord, they challenge that no decree can be drawn up, my lord, on the basis of this, because appeal is pending and money should not be disbursed. And this, my lord, decree has to be drawn up, my lord. Your lordship will.
Prefer stay of operation of the judgment and order. Stop. The prayer is considered and refused.
Lordship.
I am for the official.
But I for the appellant, Millard, I am most humbly praying for a not today, Millard. Shobhapriya Mukherjee is.
On the prayer made on behalf of the appellant, let the matter stand adjourned for the day.
My lord, 5 and 6, my lord, I am for the respondent, my lord. On the last occasion also, my lord, they have. Not 5 and 6, my lord, I am for the respondent, my lord. On the last occasion also, they have asked for time. And my lord,
Second call dismissed. Pass over.
Item number 9. Item number 10.
The 10, I am appearing for respondent number 3 and 3B. The day before yesterday, we have received the voluminous paper book. We have informed our client that I am paying 2 weeks time.
Pass over.
Item number 11. Item number, second call, item number 5 and 6.
Give your appearance. Usual formula in our court. But you know that
earlier once the matter was dismissed, but before your lordship's
that may happen today also.
hopefully not. Hopefully not.
জানো কি করবে? হ্যাঁ কি লিখবে বলো তো? দেখি কিরম শিখেছো। In the first call, appeared for the appellant, stop. In the second call also, nobody appears. Stop. No accommodation is prayed for. Paragraph. The appeal is dismissed. Is dismissed only, along with the connected application being such and such. Stop. Interim order, comma, if any, stands vacated. 5, 6, same away. 8, 8.
Second call, item number 9.
Same order. এখানে খালি application নেই.
Second call, item number 10.
Same order. Give your appearance.
Item number decree. Item number 11.
শোনো পুরো লিস্টটা কল করো তারপর টাইম পাবে ওরা আসলে যদি আসতে চায়
Item number 13. Item number 14.
Lord, I am appearing for the respondent.
Item number 15. Item number 16. 17. 16.
Not today, not this week, my lord.
16. You're for the appellant.
Yes, my lord, for the appellant.
Not this week.
Not this week.
On the prayer made on behalf of the
Devnath
appellant.
Ghosh is appearing, my lord.
Prayer made on behalf of the appellant. Let this matter stand adjourned for the week.
Grateful, my lord. 16. তোমার নাম দিয়ে দাও।
Item number
16. Yes.
Item number 18.
17. 17. Lord, I am for the respondent.
17 কল হয়ে গেছে ঠিক আছে এই
Item number 20.
Lord, I have a cross appeal, my lord, in this matter.
where is that not listed
It listed. Lord, I think I am told, my lord, I am instructed that the main appeal has been dismissed by your lordship, but the cross appeal survives.
dismissed for default
Yes.
the cross appeal isn't in the list oh no what is this then Sagar bolo
State
This-
of West Bengal's cross appeal.
no this is the appeal this is the APD
Yes, this is the appeal.
Yes, pass over. Or if you like, we can list your appeal, cross appeal along with this.
Yes, Lord will kindly will not do that.
Give your number.
Possible. Lord, it is there. Your Lordship will kindly will not take it up.
Give the number.
In the course of the day, my Lord, I'll give.
করে দিও অর্ডার দিচ্ছি না একসঙ্গে করে দিও এটা নট টুডে থাক because of your cross appeal the appeal got saved
and 22. Three. Four.
তো একসঙ্গে তিনটে একেও না ঠিক করে
26. 27. 28. 30 from order. 29. 29 and 30. You want to 31.
My lord, this was being heard actually by bench presided by your lordship and Justice Chattopadhyay. Several days. If you want to, I was in the midst of giving my reply to he is the appellant, Mr. Shobhashachi Chaudhary.
whatever you say Mr. Bose
This always, if you want me to continue, I can continue.
no how can you continue this is my learned brother has not heard anything
Yes, that's
he
what I said.
either you have to start afresh from the appellant side or we will do this for the timing we remember we have heard this for the timing we'll adjourn till Tuesday there's likely to be some further change it will become clear by Tuesday
Yes, obviously.
right so এটাকে তুমি করো adjourn till Tuesday করে রাখো অনেকটাই শোনা হয়ে গেছে মানে appellant পুরো বলে দিয়েছে
নতুন করে 52. 53.
My lord, I'm for the I beg to appear for the appealant, your lordship. I'm seeking a short pass over, your lordship.
54. 35. 36.
My lord, I am the appellant in this matter. My lord, your lordship has heard the matter in the other bench substantially. It is regarding that interest.
you keep it for the timing keep it on Tuesday
37.
I'm for the respondent, your lordship.
cross over
38.
Lord, I am for the respondent.
cross over
39. 40.
40. My lord, there's an application of mine in this matter. This was again partly argued. Then the question arose that one of the parties have been substituted, has gifted the property. Lordship may recall this is this property near Kolamandir that about how much I have not been paid.
gifted to daughter-in-law
Yes. My lord, that property, my lord, whatever your lordship wants it today or it's Tuesday. So
we will get a clear picture about the determined bench.
Yes.
So come back on Tuesday.
51. 42.
Lordship, in item number 42, I appear for the appellant, your lordship. Mr. Dhruvo Ghosh is leading me in this matter, your lordship. Today I'm praying for an accommodation. If your lordship keeps it any time next week, we'll start with it.
on the request made by learned advocate for the appellant, let this matter stand adjourned for the week. Diya Sombari diye diyo list.
Great. Your Lordship, Tuesday. Thank you.
This is what you are teaching them, your juniors.
No, I know. No, I know. I was just talking to Mr. Dhruva Ghosh. I mean, give them the slightest excuse, you won't come. He's only elated over the fact that his name is appearing in the list for the first time.
What?
The matter, my lord, at 3:15.
Oh.
He told me, I didn't know.
Tuesday.
Great.
43.
43, my lord, I oppose the appeal, my lord.
Whom will you oppose? Pass over.
44.
I'm for the respondent, Your Lordship. I'm for the respondent, my lord.
What is happening? None of the appellants is present today. Chalo, pass over.
It's mentioned.
45.
45, I'm for the respondent.
Bojo. Chalo.
Lord, I am for the appellant, my lord. But we have completed our submissions, my lord. But the respondent was, my lord, due to, my lord, was arguing, my lord.
Tuesday.
Excellent. Okay. And 50.
Lord, I appear for the appellant in this matter, my lord. I'm led by Learned Counsel, Mr. Vijit Mitra in this matter, my lord. He's on his legs, my lord. I was only praying for an accommodation today, my lord. If it can be taken up next week.
Monday?
Kindly on Tuesday, my lord, or Wednesday, whenever your lordship pleases.
So what's happening on Monday? We can hear you for the entire day.
I know, my lord. Reaching court will be.
Why? What is there?
I've heard of the there's some...
Tuesday, Kurida.
I'm grateful, your lordship.
51.
Lord, my appeal, my lord,
Yes.
my lord, if Lordship would kindly take it up after a fortnight, my lord.
Why?
We're trying to resolve the issue.
Very good, very good. Learned advocate for the appellant, 51. Oh, I see. Learned advocate for the appellant says that the parties are trying to settle the disputes out of court. Paragraph as requested by learned advocate, comma, let this matter stand adjourned and be listed again. 2 weeks.
Yes, 2 weeks.
2 সপ্তাহ ডেটটা দিয়ে দাও।
Great.
Lord, I appear for the respondent in this matter.
Respondent.
Yes.
Mr. Farrow Hall.
Farrow Hall, yes, my lord. Appeal from a decree, my lord. Suit dismissed on the ground, my lord, barred by law. And the appeal has been preferred.
Pass over. Pass over.
Your lordship is keeping. Lord, my other side is here.
I mean, led by Mr. Shobhoshaji Chaudhary in this matter, my lord, will kindly keep it in the first week of August. He has some personal difficulty these 2 weeks, my lord.
I'm aware. We are aware of that. On the request made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on August 4.
Obliged, my lord. Deeply obliged. I don't have any.
Fifty-four. Five.
55, I have for the petitioner, madam. Led by Mr. Chona for judge in this matter. Our last petition, the lordship has rejected me to take instruction on the matter. Now, my lord, he has shortly been engaged, my lord. I request some time, my lord.
When? Tell us.
My lord, 2 weeks.
On the request made by learned advocate for the appellant, comma, let this matter stand adjourned for 2 weeks and be listed again on
56, I am for the appellant, Your Lordship. I am praying for not today as the conducting counsel is out of station today.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the week.
Grateful.
My lord, I appear for the respondent. Paper books are complete, but I'm the respondent, and this will take some time. So if this bench is going to break
Tuesday,
whenever it's convenient.
Let us first get the certainty back. Let it be listed on Tuesday and let us see.
Yes. From DC, second call, item number 11. 11 and 12.
My lordship, may I say something? My lordship, item number 9, my lord. I am led by Mr. Deepak Parladka, my lord. I was waiting for second call, my lord. But from 11, I'm just it was dismissed, my lord. Kindly keep it on 23rd, my lord. Grateful, lordship.
Item number 13.
I'm for the respondent, my lord. My lord, it's my appeal, my lord. I have taken out an application, my lord, because my lord has passed an order because I have not complied with the order which was passed by your lordship that the occupational charges were not paid. My lord, to that, my lord, I have taken out an application for condoning the delay in filing those occupational charges for the month of March, April, and May. My lord, on the last occasion, my lord, the respondent took time for filing an objection to that.
We are not filing any opposition. I've taken instructions from my client. They have subsequently complied with the order. Well, so therefore the appeal, they can proceed with the appeal, but the application can be disposed
My
of.
lord, one of the points in that appeal was whether the suit is a commercial dispute or not. My lord, after the coming of the judgment of the T.A. Thompson, my lord.
So let us dispose of the application first.
My lord.
The application ta kothay? So therefore, the stay on execution will operate again.
Will operate because now they're compliant.
Yes. Eviction decree, naturally. Occupational charge. Issue. Operation of the eviction decree that the respondents obtained from the learned first court, honorable first court, our court, no, single judge, from the honorable first court, was stayed on the condition that the appellant shall go on paying monthly occupational charges to the respondents. Stop. Paragraph. It appears that for the months of March, April, and May, 2025, the appellant defaulted in paying occupational charges to the respondents. Stop. Accordingly, comma, by an order dated this bench, no?
This bench, yes.
Comma, we had clarified that the respondents oblique decree holders would be at liberty to proceed with the execution. Paragraph. In the above background, the present application has been taken out by the appellant, praying for inter alia the following orders. Page 8 থেকে ABC দিয়ে দেবে, ABC set out a quotation এর ভেতর করবে সবসময়। Paragraph. On the last occasion, comma, time was taken on behalf of the respondents to file opposition to this application. Stop. Paragraph. Stop. Today, learned advocate for the respondents says, comma, on instruction, comma, that the respondents will not file affidavit in opposition. Stop. The appellant has since deposited the occupational charges for the months of March, April, and May 2025, and have also deposited the current occupational charges. Stop. Therefore, comma, the appeal may be heard out. Paragraph. Since the appellant has paid the occupational charges, comma, although belatedly, comma, we clarify that the execution of the decree in question shall remain in abeyance till disposal of the appeal. You can do the appeal today or whenever you like.
Kindly fix a date,
Only, my lord, one thing, my lord has recorded that even the current ones are being paid. I've only taken instructions in respect of the defaulted ones. Whether at present, my lord, let that be their submission.
My lord, I have to take instruction for that.
Because
I believe that has been paid, my lord.
Current বলুন না, এই মে অবধি।
The application to dispose of করে দিচ্ছে since মানে
If they haven't paid again, we will lift the bar.
will it yes. Well, they can proceed with the
My lord
appeal.
is keeping it on.
When tell us.
My lord, any day
এই
next week.
জিএটা dispose of করে দাও। জিএ 2টা 21st.
My lord.
21st. আপনি তো তুমি 21st.
I know.
Yes, he will walk down.
I have no problem. 22nd, my lord.
Second, আমি নেই তাহলে
23rd.
22nd. Let it be listed on 22nd.
21st, I'll come.
All will come.
We'll all come.
List the appeal, তারপরে বলে দাও list the appeal, হ্যাঁ?
Grateful, my lord.
Second call, item number 14.
I am for the respondent, my lord.
Usual order, madam. Give your appearance.
Very well. My lord, only one thing. My lord, this is, my lord, in respect of, my lord, ascertaining the mean profit. My lord, decree, my lord, ascertaining the mean profit. My lord, the principal amount, my lord, with interest is, my lord, 8 crore 54 lakh. My lord, 4 crore is already paid by the decree, my lord, judgment debtor. And the balance amount is lying as fixed deposit with the original side register. My lord, I'm, my lord, praying for liberty to take, my lord, for encashment of the fixed deposits.
There he comes.
The last occasion, my lord, your lordship had directed them to take instructions whether, my lord, they are agreeable to our proposal of mean profits of 70 rupees per square feet. If
we can't remember anything. দেখি কি order for আছে?
It is of, my lord, that is order dated 22nd May.
Let us see. তারপরে তোর আর আমার order হবে।
I have taken instruction.
because your lordship had given this direction based on the pleadings that according to us, my lord, the mean profits would not be exceeding
65 to 70 rupees per square feet. That was the ground of challenge, my lord. The special officer, my lord, had fixed it at 89 rupees per square feet.
89.
89.
9 per square feet with
RN Mukherjee,
You will be well advised to accept 70, otherwise this litigation may continue for the next
Yes,
10
that was
years.
your lordship's observation last time also.
settlement, but ultimately it did not happen, my lord.
That was long time back.
No question of trying for settlement, madam. Please understand. Either your client accepts 70 or doesn't. If he accepts 70, if it accepts 70, litigation comes to an end. If it doesn't, litigation continues. That's all.
My lord, I have taken instruction apropos my
Not
lord's
agreeable to accept at 70 rupees.
my lord, 80 rupee, my lord, per square feet. That is my instruction. And if it is, my lord, paid within, my lord, 2 to 3 months, then, my lord, we are agreeable.
Forget about it then, because they will not be able to go up. It is only because in the pleadings it is said 70 figure is there.
They are pleading. my lord.
Yes. So then let us hear the appeal.
My difficulty is only difficulty, my lord, is I intend to cite certain judgments. I have only one copy. I can't look at my junior.
You want time?
No, I can proceed. I don't want to waste your lordship's time. I can proceed.
No question of that. But if you are handicapped, we can grant you time. If you want to cite judgments, but if you have only one copy,
yes, that's the whole problem.
That may not be very convenient. Where is your advocate on record?
He is my junior, my lord. I can't look at him. He is not here.
Make a missing diary. Not today.
That event, my lord, I am led by Mr. Chaudhuri in this matter, Mr. Shobhushaji Chaudhuri.
In that
My lord,
event, 4th August.
Lordship.
August 4.
Lordship. Late to my lord.
Second call, item number 15. My lord, I am led by Senior Counsel Jayanta Kumar Mitro. My lord, I am seeking time in the second call because Lordship, I was stuck in court 6. By the time I could have reached this court, the matter was called on, Lordship. I am praying for 1 week time to get ready in the matter.
You are not ready.
No, my lord, I am not briefed in this matter. Mr. Jayanta, I am led by Mr. Jayanta Kumar Mitro.
You are led
Senior
by him, but you are not briefed.
My lord, I am the dealing advocate only.
Oh, then it has to be adjourned. On the request
My lord,
made.
1 week.
1 week. Sure. We won't grant 1 week. Acha. On the, not 1 week, on the request made on behalf of the appellant, let the matter stand adjourned for 7 days and be listed again on what 7 days now, 1 week.
Grateful, your lordship.
Item number 17.
Answer the respondent, my lord, in this matter.
Mr. Saurabh Mukherjee is appearing on behalf of the appellant. His father was being hospitalized. Today he is being discharged, so he is not in the court.
What do you want? Tell us.
So please, kindly, not today.
Not today. On the ground of there being a medical issue in the family of learned arguing counsel for the appellant, adjournment is sought for. Paragraph, list the matter once again. Acha, tomorrow? No, tomorrow? Let the matter. Huh?
22nd of July, my lord. May it be on.
It's the matter once again on July 22.
May I file my affidavit in reply to GA2, my lord?
What is GA2?
My lord, GA2 is my dismissal application.
Paragraph. Affidavit in reply filed on behalf of the respondent in connection with its application for dismissal of the appeal, comma, is taken on record.
I'm deeply obliged.
Grateful.
Item number 18.
Usual order. এই জানেন তো usual order জানেন তো?
Item number 19.
My lord, Mr. Haradhan Banerjee appearing on behalf of the appellant. Well, he is suffering certain illness. I'm praying for the 3-week time.
3 weeks?
Yes, my lord.
On the ground of illness of learned senior counsel representing the appellant, comma, adjournment is sought for. Paragraph, as requested, comma, list this matter 3 weeks hence on নাম নিয়ে না
Item number 21 and 22.
Sir, I found 20.
20 was made not today, just give the number.
I have the number. Wait.
Item number 21 and 22.
Usual.
Second call. Item number 22, 23 and
23, 24, 25. 23, 24, 25. Lord, I appeal for the respondent. Lord, your lordship.
I appear for the appellant.
Mr. Bose, my lord, is leading me in the matter, my lord. We have, my lord, submitted that my client is, my lord, around 90 years old. And your lordship was pleased to, my lord, direct the matters to appear within first 3 matters.
এই কেন ফার্স্ট 3 আসছে না তাহলে?
These are the orders, my lord.
দেখো অর্ডার আছে
জজ সাহেবকে দিন না।
করে দাও 22nd জুলাই উপরের দিকে তুলে দাও বলেছিলাম মনে আছে
Grateful to your lordship.
Item number 26.
For the respondent, my lord. It's not decree, my lord.
not interested you see
Anyone?
has to be we have to pass the same order with the understanding, as you know, if in course of the day they mention it will
No, obviously.
dismissed.
And
along with the connected application,
Second call, item number 27.
But I appear for the respondent.
Twenty-seven, my lord, I am for the appellant. I'm praying for not today.
on the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
Grateful, my lord.
Second call, item number 28.
But I appear for that. I appear for the appellant, my lord.
Respondent is there, Mr. Kaur?
My lord, your lordship directed
Yes.
a notice of appeal to be served on the respondent. I don't know. Okay, sorry. Lord, I'm told it has been served.
Where from will we get that?
By the department it has
By
been
the
served.
department, দেখো তো কিছু আছে কিনা।
Lord, previously we used to, as solicitor, serve the notice of appeal, but now it is being served by the department.
ডিপার্টমেন্টকে ডিরেকশন দিয়েছিলাম তো আমরা। ডিপার্টমেন্ট যে সার্ভ করেছে সেটা কোত্থেকে পাবো? Who is the advocate on record for the respondents? Does she know? Ask her.
Yes, they appeared in the trial court.
Shurmishta Das.
No, she is my
Respondents.
respondents. They appeared for the respondents in the trial court.
She is Shurmishta Das.
She is Shormila Das.
বুঝতে পারছি না তো সেটাই। ইনি নোটিস অফ অ্যাপিল রিসিভ করলেন, হয়তো নোটিস অফ অ্যাপিল অ্যাপেলেন্টকে কেন দিয়েছে আমি জানি না। শি ইজ দি অ্যাপেলেন্ট। Is this her June signature? Just please ascertain.
Shormila Das.
It
It is her signature on her behalf.
That's right. So where do we get that the respondents have been served? We are calling for a report from the registry, Mr. Kaur.
Yes, report is here, my lord.
দেখো তো কি রিপোর্ট আছে বলছে।
Yes, this is the report. Lord, previously a notice of appeal was being issued.
Notice to respond. This is the notice. There is nothing in this which shows actual receipt of the notice by the respondents.
My lord, your lordship will call for a report from.
That's what we are saying. Hey, Esho. By an order dated June 11, 2025, a coordinate bench had directed the department to issue notice of appeal to the respondents. Stop. Paragraph. Hey, Kaushik. Learned registrar, original side, is requested to file a report on the next date as regards whether or not such notice has been served on the respondents. Paragraph lists the matter once again next Thursday. এটা রেজিস্ট্রারকে পাঠিয়ে দিও ওরটা তারিখটা দিয়ে দেবেন থার্সডে না তারিখটা
My lord, I was praying if it could be 22nd of what day?
22nd
Your lordship,
Tuesday.
Tuesday.
There won't be sufficient time. Today is Thursday.
Very well, my lord, let it be Thursday.
If you want it beyond that, we can keep
No,
it.
my lord, I want to finish it, my lord.
24th.
Look at it. My lord,
That mean profit again.
my lord, mean profit, my lord. This matter was substantially heard by the other bench, my lord. My lord,
Very well. We'll keep it tomorrow then.
Lordship.
Pleasure to fix a time.
will take an hour.
Some precedence in your lordship.
But updated the matter as appearing as item number 1 under the heading. But yet, my lord, we have taken an adjournment in the execution today, my lord.
No time can be fixed.
My lord, I was praying if it can be placed a little higher up, so that
Higher up. This is the number 1 appeal from order. You see, what we are doing on alternate days, appeal from order will be first and appeal from decree will be on alternate days. So today appeal from decree is above appeal from order. Next day, appeal from order, it will be reverse.
Let it retain its position then.
Of course.
It's almost heard, my lord. It's only will take 1 hour. That's
We'll just say not today.
no.
Yes.
Your lordship passes an order.
Leho. Let this matter stand adjourned for the day and be listed tomorrow under the same heading, retaining its position.
I'm extremely grateful, but extremely. Otherwise, difficult situation.
No, we understand.
Grateful.
चलो रखो usual huh? ये तो सीधे
Right. Number 33 is an application under section 37. My lord, this matter is ready for hearing. Paper books have also been filed. My lord, but today I am in some difficulty because the brief is not there at my behest because of some miscommunication. My lord, may it appear anytime next week. My lord, we are ready to do the matter. It was notes and everything is ready, my lord. We can proceed.
on the request made by learned advocate for the appellant. Mama, let this matter stand adjourned and be listed again on, tell us any days.
Or any date except 24th, we shall be here, my lord.
Monday,
Monday, yes, my lord. Monday.
February 21,
July 21.
July 21. Yes.
Much okay.
34, 35, Mr. Shuman Dutt, senior advocate, is leading.
Appellant.
I'm for the appellant. May it be taken up next week, Lordship.
Give us a date, Ms. Addo.
Any date except for 21st, Lordship.
26th.
26th. Friday, Lordship. Saturday, though. 25th.
Why did you agree? Why did you say yes?
I did not say. Mr. Ganguly was convinced that it would be a very
23rd.
convenient date for him.
On the request made by learned advocate for the appellant, let this matter stand adjourned and be listed again on July 23.
23rd. I'm grateful. Great.
একই অর্ডার হবে।
This is, my lord, my appeal from dismissal of section 34, my lord, filed by me by the learned trial judge. I have a leader, my lord. The learned AG is leading me, Mr. Dutta. But I am ready if he opposes.
No, we know you're ready. You're always ready. To be fair to you, you're always ready. You wish to do it or you don't, just tell us.
I'll start, my lord.
Is Mr. Dotto available today?
5 আসবে কি? আমি বলুন কি করব? Then my lord will keep it on.
Not this week. On the prayer made on behalf of the appellant state, capital S, let this matter stand adjourned and be listed again on Monday.
Next
Apocalypse মনে হচ্ছে. The world will come to an end on Monday.
No, not it's not about
Tuesday, February 22.
9th adjournment granted.
9th
9th adjournment granted.
No, then next day, Mr. Banerjee,
And
if your leader is not available, please do it.
And
It's
in
not
this matter, Supreme Court has passed a direction that despite the issuance of notice, the hearing is section 37 to
I
continue.
will start.
And every time Ms. Banerjee is being very fair, every time she is very fair, she comes to the court and says, I am ready and I have a leader. And the matter gets adjourned. And she's
If
very
you-
fair. Very fair.
Then you start. Then you start.
Any date, Lordship, I have no, but let it be.
Then next date, let it be understood, you will not mention that you have a leader. Straight away, you will start.
Thursday, Lordship keeps it on Thursday. I
Thursday.
Still, my lord, now that NCLT is there, my lord, we have to fix
Tuesday,
this
Tuesday,
Some-
Wednesday,
Yes.
Wednesday রেখে দাও,
Yes, Wednesday.
তারিখটা দিয়ে দাও।
Highly
Great. Hey.
My appeal, there's an order to make valuation and for us to buy the property. That order, Millard, they have to file the valuation, Millard. Valuation, Millard, I have to tell whether it's done.
My senior, Mr. Ranjit Chaudhary, appearing for the official liquidator, my lord. My instruction is that he is engaged in another court.
Valuation, Millard, হয়ে গেছে, জান? Millard, both parties were there, Millard. Valuation in presence of both the parties. That has been done. It's the nature of disclaimer. The property maximum price has been given. Valuation, the honorable bench felt, Millard, that 2.5 crores or whatever other value, other things I have to put in that amount. Millard, that amount, Millard, I'll put in, Millard, and get the property. That's all. It's after all, Millard,
Where is the valuation report?
I don't know. They have to file it.
He has no clue.
The order of Millard, 6th of February 2024, passed by the bench presided by Honorable Justice I.P. Mukherjee and Honorable Justice Vishnu Vijay.
Mr. Ghosh, ask your junior to contact Mr. Chaudhary if possible. We'll pass it over if you like, so that he knows nothing about the matter. Shall we pass over or adjourn it for the day?
Pass over করবে না adjourn করবে?
My lord, may kindly adjourn for the day, my lord. He is engaged in court 26 that way, my lord.
The official liquidator is not, no. On behalf of the official liquidator, accommodation is paid for. Paragraph, Mr. Ghosh, learned advocate, senior counsel, appearing for the
Millard, I appear for the appellate.
appellant, Bhashdeep. Appellant says that pursuant to the order dated
Millard, the order is
February
dated
2024.
6th of February 2024.
February 6, 2024, passed by a coordinate bench, valuation of the property in question has been made. Stop. The appellant is prepared to put in the money and obtain possession of the property. Paragraph, since accommodation is paid for on behalf of the official liquidator, let this matter stand adjourned and be listed again on Tuesday. It should take for 5 minutes, marked 1 p.m. so that it can be disposed of. They can have one
Very
thing.
kind to your lordship.
We have fixed the matter, the time. Please tell Mr. Chaudhuri.
What's justice?
You.
My lord, Justice Rai, my lord, it's some microphone. Oh, that's the gong. I thought it's a microphone, something device, lordship voice. I thought, my lord. Sorry.
My lord, I appear for the appellant, my lord. My lord, in this appeal, we've challenged the order by which the special referee's report determining mean profits has been set aside, my lord. So we had completed our submissions.
Chaudhary was to address your lordship, my lord, on a one particular issue raised by Mr. Jishnu Chaudhary, my lord.
That for lease deed.
Yes, my lord.
Lord, he's
Best
not there
evidence.
today, and I'm told, my lord, till 31st of July, my lord, he has some difficulty.
4th August.
4th August, my
Very
lord.
good.
And my lord will not take me amiss. My lord, there's another matter, item 11, 12, not there. Mr. Pradeep Ghosh, my lord, was appearing. He did not know, possibly there was some confusion. He did not come to court today. Has been dismissed for default.
Mr. Pradeep Ghosh, Harish Mukherjee Road.
Yes.
11, 12 টাই করো, not today করে রেখে দাও।
I'm so grateful, man. I'm so grateful.
ওদের কাছে একটা মামলা করছি। তো ব্যাখ্যাতে বলছিল বিফোর ভ্যাকেশন উনি ভার্চুয়ালি ছিলেন। Yes.
We'll come back on 4th August.
কোনটা? এমনি করে দাও 4th August। এসে গেছিলে ওদের 3:30।
Your Lordship, I am the appellant in this matter. The last occasion I have taken time on the ground of settlement, and the settlement is at advanced stage. But
Progressing.
It's progressing, but it will take some more time if it can be kept in the monthlies of September, Your Lordship.
Then it will never be settled, Mr. Shorkar, but we are keeping it in September. Mr. Shorkar, learned advocate for the appellant, says that talks of settlement between the parties are at an advanced stage. Stop. As requested by him, let this matter stand adjourned and be included again in the monthly list of September, 2027. কেউ শুনে না, দেখেছিস তো 27 বলে চেক করে।
The appellant is not here, my lord.
You are for the appellant?
No, I am for the respondent. But this is lordship was here. The other bench was hearing the appeal, my lord. Rejection of a Section 8 application filed under the Arbitration Act.
We'll keep it on Tuesday for the time being.
Or respondent.
Second call, item number 44. I for the respondent, Your Lordship.
Usual order, give your appearance.
Second call, item number 45.
I'm for the respondent. I'm for the respondent.
Same.
Second call, I can go 47.
47, I am for the appellant, my lord. This is, my lord, the decree. This is the appeal, my lord, against my lord order, where, my lord, our execution application has been rejected on the ground that there was a compromise decree against the tenant. And the execution has been rejected on the ground that a fresh tenancy has been created.
Justice Sinha Roy.
Yes, my lord. May I start the matter, my lord?
Yes, that's entirely your wish.
Yes, my lord, I can. I am led by Mr. Shatarup Banerjee, my lord. And I can start the matter.
Will you keep us occupied for the next 15 minutes?
Yes, my lord.
Then we can release your learned senior and junior friends.
Yes, my lord. 15 minutes.
You will continue.
Yes, my lord.
But Mr. Mitro has to stay for the 3:30. For the 3:30. Oh, is it 3:15? Oh, I see. Oh, yes. In the goods of Pravit Chandra Sen.
I'll make one. May I start, my lord? But initially, the suit has been filed for the eviction of the tenant, my lord. And suit has been filed in the year 1986, my lord.
1996.
1986.
86.
And in the year 2024, my lord, after so many negotiation, therefore, my lord, the one terms of settlement has been, the suit has been decreed by compromise, my lord.
24.
2014.
14.
Yes, my lord. And my lord, it was decided, my lord, the property was initially 1,000 square feet.
Correct.
I appear on behalf of the respondents, my lord.
Correct.
I appear on behalf of the respondents, my lord, led by Mr. Kaur, my lord.
Why? Led by?
Mr. Anirban Kaur.
Yes. Very well.
Yes.
Let her continue.
Yes, my lord.
The terms of settlement is, my lord, at page 89, my lord.
The stay petition, though.
Stay petition. One. Stay petition একটাই আছে। ও page 89. The tenancy was initially 1,000 square feet, and thereafter 1,500 square feet has been surrendered by the tenant, and he remains in the possession for the 500
Tenancy was
square feet.
initially 1,000 square.
1,000 square feet, 500 square feet thereafter, as per the compromise decree, my lord, 500 square feet has been surrendered by the tenant defendant, and thereafter he continued in possession for 500 square feet, and the rent was then extended as rupees 2,000 per month. And there are other terms, my lord, which says, my lord, if he has not complied with the terms of the terms of settlement, then we shall have the right to execute this decree without filing any fresh suit.
Yes.
And the tenancy would be for 10 years, and after 10 years, my lord, they will hand over the possession, and if not, then also we can file execution. That was the terms, my lord. Then we initially filed the execution
initially we have filed one execution in the year 2015 because they are stopped paying us the rent. So thereafter, after filing the execution application, they started paying rent. So execution application disposed of. Then again in the year 2021, when they stopped paying the rent, we have filed the execution application. Now, my lord, two aspects. One aspect, they says that we have filed, since we are not accepting the rent and we are not issuing the rent receipt, they are starting paying the rent to the rent controller. So we said that cannot be the as per the terms of settlement. You have to pay us the rent, and there you have just they said they have sent a money order, but we showed that the money order issued by some other person. That's why you have not accepted it. But that aspect now gone, my lord, because 2010 years, 2014, 23rd June, and that has the 10 years time limit has also been expired, my lord. Now it's 2025. But since the order has been passed that the execution cannot be granted because the new tenancy has been created, therefore we need, therefore, my lord, we cannot even execute again, file execution case. That is the, my lord, issue. Now, my lord, kindly come to our application, my lord. Terms of settlement as page 89. May I indicate the terms, my lord?
Terms of settlement is dated?
That is 23rd June, my lord. 2014, on the same date when we got the decree, my lord.
23rd June 2014.
Yes, my lord. May I read the terms, my lord?
Mr. Banerjee, next day, it is 3:15, we have fixed a matter. Please, we have read the judgment. We have read the judgment. They will have to defend it.
Sir, what fell from Justice Sen on the last occasion he had heard, Malad, quite an extent, is that leave apart everything. Today the tenure is as it is over. So you have to vacate.
Yes.
Leave apart the law, leave apart everything. Today the tenure is already over.
Our case is that, my lord, it's a fresh induction.
Fresh induction. That is exactly what Justice Sen said, that even if I take the fresh one, even if I'm not accepting your case at all, even if I accept the fresh one, that has also come to an end. So you have to vacate the premises.
And the executing court also can't go behind the decree.
Exactly, Malad. That is what I will.
Chalo, dekho. We will upgrade it because we have started hearing it.
Yes, Malad.
We have heard Mr. Shatarup Banerjee, Learned Counsel, assisted by Ms. Shomali Mukhopadhyay, Learned Advocate, representing the appellant. Stop. List this matter once again. কবে রাখবে? Tuesday. এটা কি Tuesday?
29.
My lord. Can it be Wednesday, my lord? Because
Wednesday দিয়ে দাও.
Wednesday কত তারিখ? 30.
Amongst the first 5 items under the heading, এটা কিসে আছে?
সকালই হয়ে যাবে.
Appeal from orders. Under the heading, amongst the first 5 items under the heading, appeal from orders.
But instead of, can it be on Tuesday itself, my lord?
He has some problem.
Or then, my lord?
Then Thursday?
I'm not there,
Friday? Monday week?
Yes.
Tuesday week?
No, Monday week, my lord. Monday. Great.
Monday week এর তারিখটা দিয়ে দাও.
Before your lordship takes up the fixed matter, my lord, item number OD 10 has been dismissed for
Which one?
OD original side daily list item number 10. I could not.
10. You're for the appellant?
Yes, I have informed my.
10টা ইয়ে করে দাও, not today করে দাও.
Milord, kindly fix this matter on 24th, Milord, because the
24th করে দাও.
We have solved the paper book.
চলো 3:15 রাখো.
Prayer for item number 21.
21.
26.
26.
Your Lordship, item number 5 and 6 appear on behalf of the appellant. The matter was called and was dismissed for default. Uh,
5-6 করে দাও।
much obliged, Your Lord.
এবার ডাকো।
My lord, before my learned senior starts, my lord, I wanted to intervene in this matter because I'm also affected by this order. I have filed 2 probate petitions in this court, which, my lord, are not being listed because of this order, compliance of this order, my lord. So, my lord, I'm
Mr. Mukherjee, nobody is opposing this appeal. Everybody is supporting this appeal. Don't make things complicated. Let us decide the point.
Well, I wanted to just help your lordship in.
You assist Mr. Mitro.
I will assist Mr. Mitro.
Yes, do that.
Yes.
Thank you. I'm grateful to your lordship for persuading him to help.
I will.
Wait, please, your lordship. Well, an interesting question has arisen in this, which is affecting quite a number of people, my lord, with their applications pending before this court for probate. Well,
Before you start,
yes.
I have to tender my apologies, Mr. Mitro. We had fixed your matter at 3:15 so that you get about 1 hour 15 minutes.
Yes.
After that, without remembering that, we have fixed that larger bench matter at 3:30.
Yes, I saw that. I
Yes.
saw that.
So will you begin today because there's hardly any time?
This is absolutely up to your
Or we
lordship.
can fix another day and hope that we don't make a mess.
Give me 1 hour, my lord.
Yes.
Then I will be able to conclude my submission. And perhaps, my lord, it will be necessary to have a continuous hearing
Yes.
to keep a track with regard to the provisions of law in the statute and, my lord, the judgments which have been decided. Unfortunately, very vital judgment, one of the most important judgments, has not been properly interpreted in this impugned judgment. So I will have to, I am going to criticize this particular judgment which has been delivered on 2 grounds. Number 1, the non-appreciation of the provisions of the statute, particularly, my lord, completely ignoring the latest patent, which, my lord, I respectfully submit to your lordship. We cannot just get rid of latest patent just like that. Yes, of course, if there is a subsequent statute modifies the latest patent, of course, we will have to abide by it. But so long as it is not totally abrogated, latest patent cannot be ignored. And clause 34 of the latest patent, my lord, I shall heavily rely upon that. And in support of that, my lord, I shall rely upon judgments which, my lord, had not been properly paid respect to in the impugned judgment. Then, my lord, there are Supreme Court judgments. My lord, I tell you, lordship, what happened in this case. The matter was heard long time back. The point I took in this appeal, in this application, was very simple point. Apparently, my lord, the judgment was not delivered for a long time. The learned judge perhaps most likely forgot about my submissions. And his lordship went into matters which were not argued at all by any of the parties. And, my lord, all the parties are present.
You did not file notes of argument?
No. And, my lord, so what happened is this, by reason of, my lord, taking into account so many other things which were not argued, my lord, actual point, my lord, completely lost its way in a morass of judgments, or a lot of discussions on jurisdiction. And, my lord, unfortunately, the tenor of the judgment is such, if your lordship looks into it, it goes into it deeply, it seems, my lord, the Calcutta High Court had been totally denuded of its jurisdiction, testament-free jurisdiction in this judgment, which is not the case. And that is, but, my lord, nobody challenged the jurisdiction of the court, but the learned judge went into it. So I will have to go into this judgment for the purpose of, my lord, taking your lordship into points which would not be ultimately germane. This is a very peculiar situation. The points I shall have to urge before your lordship in order to assail this judgment are points which were not germane in actual fact. But then again, my lord, this judgment should not remain, because if this judgment remains, then there will be a lot of problems insofar as the litigants are concerned in coming before this honorable court in testamentary jurisdiction.
You had also referred to chapter 35, rule 9 or something.
Yes, my lord, yes.
Of the original side.
Yes, because the point is this, simple point is this, that if the heirs and legal representatives all agree to the grant of probate, then there is no question of issue of citation. And citation is not issued. And that is what, my lord, chapter 35 says. Now, the short question is this: if citation is not issued, because, my lord, everybody is, all the heirs and legal representatives and beneficiaries are agreeing to the grant of probate, then the question of copy of citation does not arise. Then if one of the properties of the testator is situated outside jurisdiction, would section 283 subsection 3 of the Succession Act apply? Because that says, subsection 3 says, I'm just indicating to your lordship, that when a citation is issued in terms of subsection 1, then copy of the citation is to be annexed or affixed on the property which is situated outside jurisdiction. The simple point I heard before his lordship was that, look, citation is not to be issued in a case like this where everybody is agreeing. And then there is no question of copy of a citation to be. Is a copy of a citation is to be, my lord, affixed on the property which is situated outside jurisdiction. So if the citation is not issued, how can copy be issued? This was the short point. So learned judge said, supposing the testator concerned in a particular case, he had an heir or legal representative or a beneficiary who has not been cited and who is outside jurisdiction, then what happens? If you do not issue the citation in that property, then there is some defect. To that, my answer was, section 263 of the Succession Act is there. That will be a defect going to the root of the problem. If there is a defect, then under section 263, the beneficiary who has been deprived, he can come and make an application on the ground that there is a defect in the proceedings. Therefore, the probate is to be set aside. So there is no problem with regard to that. But nonetheless, it seems, my lord, I could not impress the learned judge. It's my failure, I take it. And my lord, the learned judge went on to say that citation, if a property is outside, it is imperative that a citation has to be affixed on the door of the same, even though no citation is required to be issued. So this was the short point involved. But, my lord, we have gone into this in this judgment, my lord, your lordship, if your lordship has the occasion to look into it, there is a lot of issues, questions have been raised.
Next Friday, not tomorrow.
Not tomorrow.
12:15.
Yes, sir.
1 clear hour.
Yes. I'll be able to conclude my submissions on that.
Lekho.
Only time I shall take before from your lordship is for placing the judgments. There is
এই শোনো, জাজমেন্টটা পড়ে আসি আমরা, সুবিধা হবে। এটা দিয়ে দিও।
May I request for any other day than next Friday?
হ্যাঁ?
May I request for any other day than next Friday? Any other day?
বুধবার টুধবার কোনোদিন হচ্ছে আর কোনোদিন?
Wednesday is my original set day.
Then Monday, following Monday at 3:30.
Okay.
At 3:30. Monday 3:30s are safe.
Monday week, Monday
Monday week, yes. We have heard Mr. Joyanta Kumar Mitro, learned senior counsel, representing the appellant. Stop. Paragraph lists this matter once again on July 28, 2025, marked 3:30 p.m., for further hearing.
Within brackets, partnered. Well, kindly make it part, my lord, because
It may not be necessary, and you will understand why I say that.
because my lord, we are getting rather jittery when we see today, for example, we found, my lord, your lordships are not sitting. So,
that was the list.
on the list, within brackets, boldly not sitting.
Which list?
Today's list. Today's original side list not sitting. But my matter was fixed at 3:15. So I was wondering if your lordships do not sit, how my matter would be taken up at
না
3:15.
ভুল আছে তো কোথায় তা আমাদের দুজনের নামে বলা আছে সিটিং এট 2 p.m. আরে লোকে কি করে বুঝবে?
No, your lordship's names are there at the top in a very small letters, prints, very small prints.
That caused a lot of confusion today. অনেকে briefing করে।
It may not be necessary. We are telling you, come back on 28th, we'll be there. We should be there.
But your lordships will be sitting on Monday week in this bench. That is one very important factor.
Even if that is not the regular bench, we will sit. Oh, then that would help, of course.
That is why it's parted.
All parties say so?
Yes. All parties are here. সবাই রয়েছে। একটা পার্টি তো নয়।
Bigger. Since we have heard this matter at some length, on the request of learned advocates who are appearing today, let this matter be treated as heard in part by this bench.
Very good.
I'll finish it within very short time.
You had last cited 2010 8 SCC.
Yes. Notes. Next, my lord, now I cite 2010, yeah, Supreme Court Weekly 1852. After we can read.
না না নোটস কয়েকটা ছিল
Yeah, Supreme Court Weekly 1852.
আচ্ছা
Kindly come to paragraph 20. In view of the above, Margot.
Yes.
In view of the above, the law can be summarized that the High Court has the power to initiate the contempt proceedings suo motu for ensuring compliance of the order passed by the court. However, contempt proceeding being quasi-criminal in nature, the same standard of proof is required in the same manner as in other criminal case. The alleged contender is entitled to the protection of all safeguards, rights which are provided in the criminal jurisprudence, including the benefit of doubt. There must be a clear-cut case of obstruction of administration of justice by a party intentionally to bring the matter within the ambit of the said provision. The specific charge has to be framed in precision. The alleged contender may ask the court to permit him to cross-examine the witnesses, that is, the deponents of affidavits who have deposed against him, in spite of the fact that contempt proceedings are quasi-criminal in nature. Provisions of Code of Criminal Procedure 1975 so and so evidence are not attracted for the reason that proceedings have to be concluded expeditious. Thus, the trial has to be concluded as early as possible. The case should not rest only on the allegations against the alleged contender. The proceedings must be concluded giving strict adherence to the statutory rules framed thereunder. Quasi-criminal character, criminal, like a criminal trial, charges have to be proved. Specific charges have to be made, which has not been made. Just affidavits have been given to us. And my lord, all the, my humble submission is paragraph 22, 20, what are the ingredients for coming? All are absent here. Just once my lord, I take your lordship, the charges, allegations against me, charges have not been framed, allegations. Kindly come to my lord, just. That paragraph. Paragraph 7 of the affidavit in our case, filed by these persons. Paragraph 7. TRL CP 7. Seven. Evidence. that 7. That after that one Kunal Ghosh, spokesperson of ruling party of the West Bengal, organized a press conference with above mentioned persons and others tried to prejudice and or interferes or tenders to interfere with the due course of judicial proceeding. Said Kunal Ghosh also tends to interfere with the administration of justice and also tends to obstruct the administration of justice in several manners. He has failed to show respect towards this person. Well, this is a charge. Very vaguely, this has.
Mr. Banerjee, the conference was held, this press conference, during the continuance of that agitation.
No.
Subsequent.
Long after. That during the agitation, Lord, I have pressed to your lordship, Lord, he was busy in another one channel that they sent a message. WhatsApp was sent. He said that I am busy in the interview. I placed it.
That was a different interview.
No. When let me take it.
Yes, we remember that.
That was
a separate thing.
Different interview. That is a news channel 18.
Right.
Complete different interview. Lord, that's political persons goes that. That's a complete different interview. Nothing with this.
Right.
Lord, all those the earlier Act 65B certificate is required. That is not also there here. Anyway, but I am not disputing this. Whatever the interview I have given, I have already shown to your lordship. That in my affidavit I have referred to this. It has nothing to do with this. And not a single time this learned judge name has been referred. If that is so, another contempt proceeding would be initiated against one of the senior advocates. I do not want to say this. I do not want to place it. He has justified. I have seen yesterday, very recent, why this, although he is appearing in this matter, out of sheer frustration, judge is not will hear the matter. So what the litigant will do? Sheer frustration, his frustration and client's frustration. I am not going there, but and regarding the one thing I have to say, that's part of this institution I am just saying, not the Kunal Ghosh I am saying. Part of this institution I am just these posters, banners, etc. of the judges were not earlier. That was not the culture of the Calcutta High Court. That was never done. First time it has come, when one of your lordship's ex-colleague, his poster was there behind the rickshaw. Tumi Bhagavan. One after another rickshaw, another poster, his poster, advertisement of the sari as dhuti and kurtas. Who has brought this degree? This culture was not there at Calcutta High Court. I am very nice, the Honorable Chief Justice on his, at his suo motu has taken cognizance in this matter, although not permissible. Why the Chief Justice did not take cognizance earlier, suo motu? When is one of the brother judges committing a breach of the dignity of the High Court judiciary? His questions are also there. In an administrative side, why did he not do? Why the 1997? Even a petition was filed in 1997, the code of conduct which has been followed by the collegiums of this by the Supreme Court, code of conduct of the judges wanted to implement this Honorable Chief Justice in judicial side, dismiss the petition, press conference, etc. Why? Sitting judge, sitting matter, taking a matter, giving a press conference. Who has brought the dignity at the end? When the question of dignity will come, dignity of everybody will raise it. Again, I have said it, your lordships will be here for 10 years or 12 years. My Lord Justice Banerjee will be here for another 6 months or 7 months in Calcutta High Court, then we'll go somewhere. Justice Bhattacharya will also be there 5 or 6 or 7 years, then we'll go to another places.
Let us be on facts.
Onward, I am coming.
Not on surmise.
Not on surmise. That will be done. That will be happen. Now, we will be here. We are more concerned about the dignity of this court and justice, judges. Now, anyway, I have nothing to collect with this. And what the police report, kindly see this. Police report given me. Not surmises, these are all calculations. And somewhere, some places, some
Only one person decides.
justice, very nicely I said. Very recently, I had just a thing. Joint Parliamentary Committee, the two, Justice Kher and Justice Chandrachud appeared there. The Justice Kher has started making his statements. Going nowhere. Later I came, after his submission, I came out and I said, how are you, sir? Why you are, how I have done, like a lawyer. And still you feel that there should be a lawyer. Yes, lawyer's life is the best life. And why didn't you have chosen there? Why have chosen? Destiny. Destiny is this everything. Now, kindly come to me the report. Report of the police commissioner report. Report was short from the police. But I am not required to read. Kindly note that one sentence. But note that one sentence. That will be enough. Kindly, I have read. Nothing has been said against my client in that report. Nothing has been.
No, we'll have to.
Nothing has been said against my client. Kindly see to that. Huh? 17th May 2025. Nothing has been said against my client. It will take long time. Nothing has been said against my client in that. Now, my lord, 2 judgments I have finished. My lord, this.
Seal করতে হবে না
But these parts, all merits, etc., maintainability of the petitions, quasi judicial, etc., all that things I have dealt with, I am not going to say. Now, Lord, ultimately, let's come to the point. Ultimately, even if your lordships are not satisfied with my answer, whatever the submissions I have made, Lord, ultimately, Lord, I have expressed my apology. Without any if or but, state, I have said so. But how your lordships will deal with such a situation? But 2016, 9 SCC, paragraph 9 to 11. বললাম তো একবার শুনিস না কান দিয়ে 2009 পেজ 543 হ্যাঁ 343 sorry 343 paragraph 9 to 11. After hearing the learned counsel for the parties, we inquired from Mr. Sibbal and Mr. Singhvi understanding of whether the petitioner is present in court, and their answer was in the affirmative. Be it stated, Mr. Rabal was absolutely clear of the proclivity exposed by the petitioner, as he has been indulging and giving interview to the electronic media regarding had to the same. We wanted the petitioner, Yathan so who is present in court, to file an affidavit. The affidavit that has been filed today, in addition to the affidavit that has already been filed on 25th, also reiterated that he tenders unconditional apology and undertakes that shall not speak on the subject in issue in public except in court's proceeding. On further hearing, it has been clarified that he will not speak to the print media, nor give any kind of interview or speak to the so and so. Regeneration. 11. Centuries ago, the famous speaker of Greece, Demosthenes, had said, articulation has to be sincere and honest. We treat that apology submitted by Mr. So-and-so, who is present, and filed the affidavit to be articulately sincere, and accordingly we exonerate him. Needless to say, if the petitioner will speak in the tenor he has spoken, that may tantamount to expressive contempt of the court. Another one, Judgment Miller. 1996, 6 SCC. Huh? Good. 1996, 6 SCC, page 466. Paragraph 12, my lord. Paragraph 12. Paragraph 12. But it, my lord, got me. But it may be pointed out that various judgments and pronouncements of this court bear testimony to the fact that this court is not hypersensitive in matters relating to contempt of court, and had always shown magnanimity in accepting the apology on being satisfied that the errors made in the publication was without any malice or without any intention of disrespect towards the court or towards any member of the judiciary. This court has always entertained fair criticism of the judgments and orders of about the persons of a judge. For criticism within the parameters of law is always welcome in a democratic system, but the news items which are concerned can neither be said to be fair or made in good faith, but which wholly false, and the explanation given in far from satisfactory is so-and-so tell the, as well as Vijay Kumar Chopra, editor and publisher of Delhi Punjab Kesari, taken the stand that they had taken the news items to be correct on the basis of the information supplied by a very senior journalist of long standing, so-and-so, but this cannot be accepted as a valid excuse. It may be stated that at common law, absence of intention of knowledge about the correctness of the contents of the matter published, for example, as in the present case on the basis of information received from the journalist report, will be no avail for the editors and publishers for contempt of court, but determining the quantum of punishment which may be awarded. Thus, they cannot escape the responsibility for being careless in publishing is without caring to verify the correctness. However, since they have not only expressed repentance on the incidents, but have expressed their sincere written unconditional apology, we accept the same with the warning that they should be very careful in future as regards the case of Dinar. So, similar, this is why I always do this. But I am a member of the privilege committee. I tell you, privilege committee, and I am the possibly I am the longest 5 years here, 26, 17 years privilege committee, and it's a quasi judicial body, absolutely quasi judicial, and decides whether there's a breach of privilege or etc. 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 There are cases of whoever comes chairman, they take my. Ultimately, is this if someone is sincerely seek an apology, all right, go. Not ethics. I am talking of privilege. Ethics is different. Privilege is different. আর কি আছে আর দেখাবো না Sri Dinanath Mishra has no doubt committed serious mistake, but he has realized his mistake and expressed sincere repentance and has tendered unconsiderable. But Dorkan, it's all right. That, my lord, here I have nothing to do. Even then, I have said. Now, my lord, kindly come to the rule which has been issued. Rule.
ফিরছি হচ্ছে 3 তারিখে
রুলটা দাও
3rd অগস্ট 3rd অগস্ট হচ্ছে রোববার 21 থেকে 3rd আমি থাকছি। হ্যাঁ হ্যাঁ
Rule jeta service hoche, order na. Rule which has been served upon us.
হ্যাঁ যখন তুমি সাড়ে বারোটা সাড়ে বারোটা থেকে মানে শুধু ফার্স্ট হাফটাই রাখবো সেটা ক্লারিফাই করবে কারণ সেখানে সারাদিন চালাবে 4:30 এই শেষ করবো। বাকি তো পার্থদা আছে আটকাবে কি এই একরকম আর স্পেসিফিক করে 12:30 কিছু আছে
ওখানে পাবেন না। আরে হাইকোর্ট থেকে যে রুলটা ইস্যু করেছে ওই দেখা দেখান আমাকে। আর না না ওটা না,
রুলের ফর্মে থাকবে যেরকম রুলের হ্যাঁ ওটা দেখি এই একটা ইয়ে করে থাকবে না না এটা না
তুমি তো জানো রুল
দ্যাট ইজ নট দি রুল।
অনিন্দিতা যেটা রুলের ফরম্যাটে থাকে না যেটা
রুলের ফরম্যাটটা আরে না রে ভাই ওটা নয়। Kindly take this one.
না আচ্ছা এটা হলেও চলবে হ্যাঁ হ্যাঁ এটা ইয়ে অরিজিৎ দা
এটা কুনাল ঘোষেরটা না, এই ফলে কুনাল ঘোষেরটা নয়, এটা অন্যরা। না and কুনাল
কুনাল এটাই তুমি রাখো তো
yes this is the one
একটা আমাকে
Did this to Kunal Ghosh residing at 1/1 Rammohn Rai Road, alleged container number 8, rule in the form HC form number 2. HC form number 2.
এটা rule. This is the rule, Mr. Banerjee.
Anyway,
Bandyopadhyay.
thanks.
This is the format in which it is sent.
This is.
পেয়েছিস তুই?
হ্যাঁ
Can I read, Miller?
পেয়েছি।
হ্যাঁ ওটাই
Whereas it has been brought to the notice of this court by Mrs. Tisha mentioned in the affidavit Ghosh, law student, that the alleged container number 1 to 8 unlawfully assembled and committed the acts of.
It's not tallying, Mr. Bandyopadhyay.
Therefore, it's not.
Not tallying.
Start with us.
7.
It says whereas it has been reported by Mr. Amitabh Ghosh, learned advocate that
No.
you Raj
Kindly
Raj.
read this. It has been served upon us. Our copy আছে?
7.
Kindly just see.
This is not the rule, Mr.
This has been served upon us. Rule. Summons.
This is the rule at the end.
Oh.
At the end.
আমার কাছে যেটা আছে সেটা অন্য দেড়টা রাজু দাস ফাজু দাস কিন্তু ফরম্যাটটা একই হবে
জজ সাহেব এটা বলছেন
This is the rule. এটা দাও নাকি ওই যেটা দিয়েছিলে
জজ সাহেব বলছে লাস্টে কি একটা আছে দেখি
হ্যাঁ এটাই
Yes. Now kindly similar. First is that this is order the rule.
Trisha Go ওটাই
Kindly see the rule is this one, my lord.
Trisha Go, yes, we got it.
No, rule is this one.
No, Mr. Bandyopadhyay. This is the rule in our format.
Let me read it. Whereas it which has been served, whereas it has been brought to the notice of this court by Mrs. Tisha so goes law student that the alleged container numbers 1 to 8 unlawful assembled and committed the acts of obstruction of justice, intimidation of advocates, scandalization of the court, and interference with the administration of justice on 25th April 2025 at 10 Kiran Shankar Rai Road, Kolkata 7,01,000, thereby lowered, belittled the majesty, prestige, and dignity of this court, and uttered derogatory, scurrilous remarks of any concerning an honorable judge of this court, with an intent to scandalize this honorable court, lower the authority in the eyes of the public, and eroding the public confidence in the judicial institution, thereby constituting grave and deliberate act of criminal contempt. It is thus ordered that a rule do issue calling upon the alleged container number 1 to 8 to so cause why they should not be committed to prison or otherwise penalized or dealt with for the acts and conducts as stated above. The rule is made returnable on 16 June 2000.
এই এটা কি, এটা কেন ডিফারেন্ট কেন? পুরো কিন্তু আমি বলছি এই যে আমাদের ফরম্যাটে রুল হয় এটাই তো আমরা রুল সই করি।
The problem is, my lord, your lordship is looking into form number 1.
Yes.
But it is form number 2, so moto. The form number 2.
But substantially it is the same.
Anyway,
Substantially it is the same.
not. Now what is the charge? Charge here that my client was assembled here also. And that is far from the fact. Far from the fact. I mean, I will be submitting this has been done for a political purpose. I have said already that these advocates whose names are there, they are not pure advocates, simple advocates. They are also politicians and completely of the opposite parties. CPM. Completely opposition. And I am the spokesperson of the ruling party. That's the reason I have brought it. Any of the single charges, whatever they are, that is not established in my case. Right from, I will not repeat whatever I have said.
That is all.
That's all my submission. I am grateful to your losses that your losses have given me very fair opportunity of hearing. very fair opportunity of hearing your losses have given us.
When is your flight to Delhi? You were looking at your watch.
6 o'clock.
6 o'clock.
Time is there. 4:30. If I leave 4:30, even 5:15, I'll reach 6 o'clock.
Any other?
Very tiring. Life has become very tiring.
Can I ask a personal question,
Yes,
Mr.
ma'am.
Bandhavata? You do not look more than 40 to 50.
But I am approaching 70. Approaching 70.
God is kind.
And every day I work at least 16 hours, 17 hours, 18 hours. And 24 into 7, not Saturday, Sunday I have. Not Saturday, Sunday. Saturday is a Saturday, Sunday is a just nightmare to me. Friday, up to Friday it is all right. After Friday, tomorrow is Saturday, day after tomorrow is Sunday, nightmare to me. After Sunday is crossed, if I get, I can say, if I get a Sunday this afternoon, I mean, if I can come back to my home and take rice and meat and get a sleep for 2 hours, that is the rest of my whole week. Bangalir mangsho bhat, Robibare. It is so enjoyable to me. And sometimes, and I need sometimes Friday evening, I get with my granddaughters and grandsons. These are my they are my oxygen now.
MB is the mangsho bhat, MB, and BG is the bhat khum.
BG is bhat khum, and that Lord is on Friday.
Yes. Any other learned advocate?
So deeply obliged, my lord. Very nice.
Thank you.
My lord, very nice.
Thank you. Any other learned advocate for the alleged?
Long days I have appeared before Justice
Yes.
Bhattacharya.
It's a pleasure, Mr. Banerjee.
It is always pleasure. Very nice. Nice, Lord, nice bench. Nice bench. Fantastic.
Have you noticed?
Sometimes lawyers get these types of chances.
This is, have you noticed B cube? Bhattacharya, Bharatwaj, Banerjee.
Telling that simply all you are 3. Fortunately, I have come. Make it 4.
Yes.
Otherwise,
Combination.
no jatra. No jatra. Deep love this.
Thank you.
Deep love this.
Anybody else for the alleged contemners?
served, my lord, upon the ILS.
No, we will hear the petitioners and whoever is supporting the contempt application later, but the contemnors,
You are for 1 to 7.
1 to 7.
Rest of the
1 to 7 in CR 5.
ওরা বোধহয় সবকটাতেই কম।
আচ্ছা আচ্ছা
এটা সুন্দর দেখতে। ফুল নেমটা জিজ্ঞেস করবো।
Sorry, we have what is your full name? We have forgotten your son.
প্রতীক মজুমদার।
Mujumdar.
হ্যাঁ
প্রতীক।
উনি 1 to 7 এর জন্য
CRLCP 5.
1 to 3 আলাদা করেছে আর ওরা You have filed separate affidavits 1 to 3 and
Yes.
but the content must be similar, exactly similar. Or
Yes.
is there some difference?
CRLCP 5.
Have you filed your affidavits in 7 also? Because you are on that.
Yes. Except Mr. Kunal Ghosh, I am appearing for the remaining.
Yes, right. So your stand must be the same in all the affidavits.
Before Mr. Majumdar starts, I believe what he is relying upon has not been served on CRLCP 7. I represent CRLCP 7, where I have not received the copy of.
Why did you point out at the outset? Should have pointed out at the outset so we could.
Doesn't matter, let him place it,
It will be served.
Let him place it, and after that he can. I'm just putting it on notice, because I have to reply to Mr. Banerjee because that's my application, but I'm like maintainability point.
Yes.
So as far as the maintainability of this suo motu contempt proceeding is concerned, I'm adopting the submissions made by my learned senior Mr. Bandyopadhyay. I will not be making any submission on that. In the affidavit, as well as today, I have only one submission, that is apology, nothing more than that. Because some things, these unfortunate events, একটু এই কে তো কল্যাণ স্যার ছিল।
এটা কমপ্লেন্ট এগুলো অপোজিশন না হ্যাঁ 1 to 7 1 to 7 to 8
ঠিক আছে এইটাতেও হবে
ওর অ্যাপোলজি দিয়েছে বলছে ফ্রাস্ট্রেশন সার্ভিসের বাজেট ঠিক হবে না frustration, verge of service, starvation. 1 to 7 এর অপশনটা পেয়েছি 1 to 7 অপশন CR 7 এ যেটা আছে সেটা পেয়েছি ও আর কি
সময় নেবে তুমি
ও তো ওখানে জলপাইগুড়িতে সব মিস করবো জামিরকে দেখতে পাবো না এরকম একটা হেলো হোটেলে আসছে সারা জীবন অপেক্ষা করে জামিরকে প্রথম নামটা খুব ডাইসি না ওটা ওই ইয়ের মতো চোকালিঙ্গামের মতো অর্থাৎ একটা এদিকে চয়ের লয়ের দোষে
of Mr. Bandyopadhyay. And at the outset, Your Lordship, my client tenders their unconditional apology. So whatever the incident that has happened, it's a very unfortunate incident. Should not have been happened. I will not justify that incident because there are some things which cannot be justified and ought not to be justified. As an officer of the court, I should not justify. But whatever happened, I can tell you, Lordship, one thing that has, I will not say frustration, but what has happened is a circumstance. They are victims of this circumstance. They have been agitating for the past 4 years, 5 years. They are waiting because they are recommended candidates. They all are recommended candidates, and because of an interim order, the entire selection process has been stalled. So obviously they were expecting that the matter will be heard out, and when the state was ready to give appointment, they were expecting that something positive might come out. But because of this interim order and everything, because of several adjournments that were granted, that is the only thing which might have triggered everything. Out of, it can be out of frustration, it can be out of some completely out of frustration. They are the circumstances beyond their control, Your Lordship. They are financially insecure, they are mentally insecure, they have families, and I can assure Your Lordship one thing, it was never their intention to dishonor or malign this honorable institution. They were organizing a peaceful protest, that is all. The allegations that has been given against my client of stampeding or stepping upon the picture of an honorable judge, I completely deny that. Because none of them either have brought the pictures or they were even near when this incident happened.
But while arguing, Mr. Bandyopadhyay had cited pictures, photographs. From those photographs, while he was seeking to argue that some of the counsel for your other sides, they are political persons and all, and they had been holding press conferences with the same persons. While saying so, he placed reliance on certain photographs which show that at least the first contemner was present in all these pictures. So therefore, isn't that a tacit admission?
Not an admission. With all due respect, Your Lordship, that is not an admission.
We have photographs annexed to the affidavits.
Met Mr. Ghosh.
Not
They
Mr.
have
Ghosh only. Photographs of the judge being cited, and there are pictures of stampeding also. Stamping on the picture. This is
7 contemners, Your Lordship.
Tisha Guho's affidavit, if you look at, in CRLCP number 7. What was the occasion of showing the photograph of the judges? In every hand there is a photograph of the judge. Must not have been eulogizing him or felicitating him. His photograph was put up. We see the next photograph, stamping. It's a bit smudged, but the contours of the photographs can be made out if compared with the previous page 10 and 11. If you see the one encircled in red, the person with the green shirt on is stamping on a photograph. If you compare with the previous page, the concerned judge's photograph, it is decipherable from that. And it's in the same, there is no case made out that any other photograph, somebody else's photo. These are the photographs which are held high.
Yes. Your Lordship, kindly have a look at the photograph. He was standing beside the photo. He was not stamping. He was not stamping on. He was just standing.
Both his feet on both sides and the photograph on the ground. Standing.
The picture, someone must have brought the picture. The picture must be lying.
Picture was lying there. He was standing.
He did not stand. He was standing over there. That is my defense in my.
This militates against your lip service of apology. This specious defense.
So I started by saying
everybody who is frustrated will set a bad precedent like this then. Whenever I am frustrated with you, I'll just take your photograph and throw it out and give a press statement or whatever. I'll make an agitation before the judge. See, this is the rule of law we are trying to protect, not a particular judge.
It's the institution. Institution has been cliched now. Not exactly the institution, the people themselves. We don't enjoy divine power. Constitution empowers us. It's by for of the people. The people have empowered us to protect them. We are the last defense. Bastion of defense is the judiciary. So if this is done in every case where there is a frustration because adjournments have been granted as per your submissions, we are confining ourselves to yourself. This frustration, where does it end? You are stamping the photograph, you are putting, holding the photograph up of the judge. Then if this is not administration, defiance of administration of justice, obstruction, what else is? He is in season of the matter and you are holding photographs. You are trying to browbeat the judge. This is a clear attempt to browbeat the judge before whom a matter is pending so that the decision goes in your favor. How can you defend this? We can't understand. This person with his both his feet apart, he's standing almost akimbo with the judge's photographs in the middle of his 2 feet. He was not aware there was a photograph there. The previous photograph shows it's in the hands of the persons present with him. Is it credible? What was the occasion of he's standing on that photograph? It was lying on the street. It flew from the air.
What has happened should not have happened.
Why are you trying to defend this? You say that the photograph might have been lying there, and he was standing it. He's not stamping.
That is why I started my submission by saying that what has happened should not be justified. There are things that should not be justified, cannot be justified.
If it cannot be justified, you go to jail then.
Is something
You cannot justify your activities, which is palpably against the institution. A matter is pending before a judge. Nothing personal, no personal allegation against him. Everything regarding that matter. So whenever a matter is before a judge, and there will be a show outside, and people will stamping on his photograph just because he's granting adjournments on the prayer of a particular party.
So the photograph reveals some of my clients or 2 or 3 of my clients who were present there, or all of them were present there. But
What did they go to do there? A picnic?
They were there. They were there. The photographs reveal that they were there. I cannot say that.
What is the reason for their being there? You have to explain yourself.
Reason being this protest that was being
Protest was
organized.
being. In that protest, you are holding up photographs, and the next scene we see is that photograph is behind the feet of somebody, and all of them. I mean, those are lying astray on the ground.
Apart from my client, I'm not justifying, but apart from my client, there were several others also who were holding the photographs.
If their names, will send them to jail also.
I'm not,
We have no qualms on that.
I'm not here to give anybody's name. I am here to just apologize for your lordship. What they have done wrong. Admittedly, what they have done wrong. They
See,
should not have done
every matter cannot be effaced. Every matter cannot be purged merely by giving apology. You do something of what sort? Not a criticism. Even fair criticism bordering on unfair, we can understand. We just ignore those things. That is happening every day. Even in a pawn shop, there are discussions about the judges after the live streaming. So we are not bothered with those things. But you are holding a photograph in your agitation. You're holding a photographs of a particular judge, putting it down the next scene. It's lying under your feet. Now, if this is not contempt, then what is? Tell us. After that, giving post facto apologies won't do. Then in every case, everybody would do that. Your frustration balanced with the rule of law, we have to take it into consideration. Frustration, what extent? Up to what extent can the frustration go?
It's a frustration, no doubt. They are victims of the circumstances.
What circumstances? And adjudication has been given by the division bench, by the single judge, division bench, affirmed up to the Supreme Court. So that is the law of the land. An adjudication that some people are tainted, some are not, whatever.
That is not related to supernumerary. That is
This is a fallout that was linked by Mr. Banerjee with supernumerary.
No. The matter which traveled up to the Supreme Court, the Boishakhi Bhattacharya matter that relates to 9, 10, 11, 12, Group C, Group D, non-teaching, teaching staff. Now, this is the supernumerary post
that was created
on 19th May 20.
The allegation is that they were in the matter. The allegation is that they were the supernumerary posts were created because that is the allegation. Mr. Banerjee was saying that he named 2 or 3 counsel, and those counsel were with these people when that happened, and subsequently assured that no, will move a matter. That is, we are entirely adopting from Mr. Bandhavate. And then this litigation was filed. Filed against what? Supernumerary post to absorb those people.
Challenging the notification.
Challenging the notification. So therefore, the other advocates took a stand diametrically contrary. Therefore, this supernumerary post is a continuation of that legacy of the previous judgment.
No. Supernumerary was never under challenge before the Honorable Single Bench or the Division Bench or the Honorable.
It was not. Certain appointments were. The entire appointments were set aside. After that, these supernumerary posts were created. We are not so naive.
What certain posts were created by a common order, common notification, certain posts to accommodate those persons who were guilty of something in that selection.
Yes.
That was the subject matter of challenge before the honorable. That was the fallout of a challenge. But this particular mirror, so far as upper primary issue is
That was never covered by the previous.
these persons are the wait-listed candidates of what will be the for whom 1600 posts need to be created for accommodating wait-listed candidates, not those persons. And that 1600 posts all being created, what we are not studying just now falling to the document. The Banerjee was submitting council was there in their meetings and their
Yes.
It is just in support of the creation of 1600 and these people will be accommodated. I have no problem. Thereafter, notifications came to be filed. On the date we were supposed to get the appointments, 1600 posts. Those we are accommodating 1600 wait-listed candidates in qualification and physical education. Writ petition, which was the subject matter, which in fact is the
These people were not covered by the previous one in any manner. Well,
apart from a common notification whereby 1600 posts were also created by the same notification.
but that was also set aside.
So
In the entire
that is
notification.
also- that is to be under challenge.
Mr. Bhattacharya, whatever may have prompted this kind of conduct, be it frustration, be it mental insecurity, instability, financial insecurity, the question is whether what they have done amounts to criminal contempt of court. That is the thing we have to decide. After that, if we hold them guilty of contempt, the question of whether we accept apology or take it as a mitigating factor, that will come later. First, we will decide. So we will hear you if once Mr. Mojumdar finishes. Yes.
And there was a direction in the division bench
Mr.
in respect of supernumerary post itself, right? And that was went up to Supreme Court. Supreme Court upheld the division bench order. But so far, supernumerary investigation.
We'll hear it. We'll hear it.
Supreme Court has stayed the CBI investigation. Honorable Supreme Court has also stayed that CBI investigation.
And will you continue?
Supernumerary or Group C, Group D, that is not the issue. The issue is whether my client's conduct is worth of an apology from this honorable court or not. That is the only issue. Things have happened, it should not have happened. Obviously, this is a very serious issue. But taking into consideration their plight, I would kindly request your lordship to grant them apology. And also they undertake that this will never happen in the future.
Next. No.
One of the contenders is CRLCP 7. Mr. Kumar, assisting Mr. Bandhu.
Oh, you were assisting Mr. Bandhavata, I see.
But one thing is not supernumerary issue that is troubling your lot. Supernumerary issue.
Different.
I said, well, the division bench judgment give some observations. Insofar as creation of supernumerary to accommodate those wrong candidates. That was put to challenge for the Honorable Supreme Court. Supreme Court by the order, that is the 17th. There are two orders. The 3rd April 2024 and the subsequent order. The 3rd April order, their lordship desired that we will hear this aspect regarding initiation of CBI inquiry separate and kept it on the following Tuesday. In fact, on the following Tuesday, for these persons, of the wait-listed candidates and everything, incidentally, we just filed an application just to be on record before the Honorable Supreme Court that these part is different from the usual selection that is gone into by the Honorable. The Honorable Supreme Court set aside the portion of the order by the CBI direction was set aside. And without the main matter remained as it is. This 1600 creation, this supernumerary for this 1600 is under challenge in the writ petition, which is being heard by the Honorable Supreme. Nothing. And in that one, on the first instance, without including these persons as parties, an interim order was made by this Honorable Court, restricting the effect of the creation of this supernumerary, nothing else. And an interim order was continued. That interim order continued for a substantial length of time. It is only on the intervention of a division bench that today the matter is now being proceeded with to the extent of locus standi of the petitioner and Mr. Bandyopadhyay also for these persons.
Anybody else for the contemnor? Otherwise, we'll hear learned advocates in support of the contempt motion. Who will address first?
So far, we are concerned. I am led by Mr. Sengupta, my lord.
He's not here today.
Oh, my lord, he will be coming
we don't
after
have time also today. We have run out of time.
Sengupta will be coming after 25th.
No, we are also not available.
Is not likely in the next 3-4 weeks. At least 2-3 weeks definitely.
No, this bench is also not available. One of us will not be in Calcutta.
You need not take the pen. You need not take the pen.
So I had a talk with him. He said that after 25th.
6th of August. 6th of August. এই যে দেখুন মিস্টার বন্দ্যোপাধ্যায় আগের অর্ডারটা কোথায় আগের অর্ডারটা দাও Mr. Bandyopadhyay, learned senior counsel, representing the respondent number 8 in CRL CP 7 of 2025, concludes his argument. Paragraph. We have also heard Mr. Pradeep Mojumdar.
Pradeep Mojumdar.
কোথায় পাবো রে?
Pradeep Mojumdar.
এখানে কোথাও নেই তো দেখছি।
Mojumdar.
21 জুলাই। Pradeep Mojumdar. Acha, for the appearing for the alleged container numbers 1 to 7. Stop. Paragraph. List this matter once again. List these matters, Karo, once again. On August 6, 2025, marked 12:30 p.m.
If it is possible for your lordships to keep it around this time, around 3-ish.
2 p.m.
2 p.m.
2 থেকে 4:30 অবধি হলে ভালো হয় না? আমার তো না শেষ তো সুবিধা তুমি বলো আমার থেকে পরিষদ অসুবিধা নেই 3:30 হলে সুবিধা 3:30 পোস্ট ফেসবুক
Or in the second half.
Wait, 3:30 p.m. Hey, Kaushik. Very, very bleak.
কপিগুলো চেয়ে নে but a one line may be added, my lord, what they're relying upon, the affidavits, whatever is not been
Mr. Mojumdar has who? Mr. Bhattacharjee or Mr. Mojumdar?
So far as contemner number 8 is concerned, my lord, we have received.
Mr.
1 to 7, my lord, we have not
He
received.
has said so in front of us.
Fair
We'll
enough.
give it.
Fair enough.
Sure.
তারপরে সুবিধা হবে সব কপি